Part 1, admission.
If I may, Your Lordship, I would like to seek Your Lordship's indulgence on item Part 2, Item 1, Your Lordship. I am appearing on behalf of Mrs. Dinari Theatre, the learned counsel for the respondent. Your Lordship, she's not able to show up because of personal reasons, and the consent of the other party has already been taken. For if this can be taken up after 2 weeks, Your Lordship.
Lordship, it's 2018 matters. So, if
Yes.
that may be fixed, my lord.
Anyway, where's Miss Dinari? Dinari and Victor L. Ralte, both of them are there, isn't it?
Yes.
What's the reason?
Your Lordship, she has some personal difficulties showing
Like
up,
what?
and Mr. Victor Ralte is out of station, Your Lordship.
Okay. Yes. Mr. Eldrindal Lomzola, learned counsel for the appellant, is present, while Miss
K. Venetia, Your Lordship.
K. Venetia appears on behalf of Miss Dinari Elazu, learned counsel for the respondent, and prayed for adjournment of the matter since the learned counsel is not able to appear due to some personal problem. In view of the above, list, when do you want it? After 1 week?
After 1 week, my lord.
List, do you want a date to be fixed? List
23rd.
after
23rd.
1 week on 23rd, 10, no, yes, 23rd, 10, is it? 2024.
And my lord, item number 11 also, the appellant counsel
Same.
is Ms. Dinari.
Okay, so in this, we will say, instead of respondent, we will make it learned counsel for the appellant, okay? And Mr. Aldrin Lomzola, learned counsel for respondent number 5 to 7.
Yes, my lord.
Otherwise, same order. List after 1 week. No need of fixing a date.
Lordship, this item number 1, we fixed on 23rd, and it was Wednesday. That was
Okay,
division bench.
so fix on 24th.
22nd.
On 22nd.
24th, if Your Lordship may.
Okay.
Okay, to make sure that they are available, make it 24th.
Okay,
Okay, and so 23rd. Yes.
Obliged.
May I seek Your Lordship indulgence in mentioning Part 2, Item number 7?
7. Yes. What happened?
Lordship, because I'm appearing on behalf of Joseph. That's Himarentle. Lordship, my senior is getting married.
Oh, very
on
good.
Next week, on Thursday. That is on Thursday.
That's good news.
Because of that, Lordship,
Okay.
Your Lordship, if I may, my Lord, this item 7 is tagged together with item 4, 5, and 6.
Yes.
And these are NDNPS appeals. That is the same judgments. And so, my Lord,
All
on the
of
last,
them will have to be adjourned, isn't it?
yes, if it could kindly be segregated, my Lord, because on the last occasion also, I understand the situation, the condition of my learned friend. But on the last occasion also, our station council had also sought for an adjournment. So, my Lord,
But what is the matter about,
matter is that
supposing they are
challenge-
segregated,
yes,
okay, and heard
challenging of the
separately.
same judgment.
Ah,
And we are the accused, that criminal appeal 14 is accused number 1, 15 is accused number 2, 17 is accused
but
number
if they
4.
all are placed in the same situation,
Yes,
isn't it?
yes,
Disposing of one appeal would also again mean disposing of the others, isn't it?
yes.
So
but,
I think they'll have to be heard together.
but their case may be a bit different, my lord.
We'll have
So I am appearing in item number 5.
Ah,
If I may, Lordship, if your Lordship decides one appeal, then it will have bearing on other appeals
yeah,
also.
these.
So
So
all the
then
appeals
they'll
will
have
be
to be
heard
heard
together.
together, isn't it?
That
If
is
the
true, but-
judgment is to be set aside, but then we'll have to see the case whether the appellants are placed similarly
Yes, it
situated
has to
or
be,
not.
yes, it has to be seen, my lord.
Then, so we'll have a look in the next date. Anyway, so for item number 4, we will say that Mr. Bilal Ramega, learned counsel for the appellant, is present.
My lord, I'm appearing for item number 6.
Okay. And in item number 6, we will say that Mr. S. Banlal Shiata, learned counsel for the appellant, is present. Then in number 7, we will say mention is made on behalf of Mr. Joseph Lal Sanhima Rentley, learned counsel for the appellant, for adjournment of the matter since he is not able to appear due to some personal reasons. We'll make it, you pass the order in item number 7, okay? Not able to appear due to certain personal reasons. In view of the above, matter is adjourned for 2 weeks, along with the connected criminal appeals number, then 14/2024, then 15/2024, and 17/2024. Okay.
My lord,
List.
it may be taken up in the first week of November.
May I pray for a fixed date, Lordship?
List on, when can we
Lordship,
have it?
if this matter may be taken up on 14 November, because right after the wedding they'll be off for their honeymoon, so
Where they're going for the honeymoon?
Bali,
idea?
Bali, Malaysia, something like that, Lordship.
Okay, list, we'll make it 14th, 14/11. Is it a
Can it be
Wednesday?
on-
No.
Lordship, can it be on 18th, Lordship? Can it be on 18th?
On 18th, okay.
18.
Or if your lordship,
Instead of
if I may make a proposal like this,
On 18th?
our item may be taken up in the first week of November first, and if
No, that'll be a problem, because then if the items are more or less the same, similarly situated, then we can write one single judgment in one hearing. Okay, along, list on 18th, 2024.
it's obliged.
Obliged.
And Lordship, regarding item number 8, Lordship, if this matter also may be taken up on second week of November.
Mention is made on behalf of Mr. Joseph Lal Sanhima, same order, okay? Learned counsel for the appellant, who is not able to appear due to some personal reason, for adjournment of the matter. In view of the above, list the matter on, list the matter after 4 weeks? 4 weeks. Yes.
For admission, part 1, item 1.
My lord,
Yes.
my lord, in this matter, we were directed to find out the correct address of the respondents.
4, 5, and 7.
Yes, my lord. My lord, despite an attempt, immense attempt, we can only come up with the same address which was previously stated.
Okay, what is the address?
NC
Where they are residing?
It's in Assam.
Then
It's the
what do
same
we do?
address. My lord, kindly allow me 2 weeks time to file.
Okay.
Have the matter. And my lord, there's been a change of authorities with regard to respondent number 8, defendant number 8. And
So you
implement
want
will-
implement?
implement will have to be filed. my lord.
Heard Mr. Alal Rokung Apautu, learned counsel for the petitioner, who submits that he may be given 2 weeks' time, another 2 weeks' time, okay, to find the correct address of respondent's number 4, 5, and 7. He also submits that he may be allowed to file an implement application since the respondent's number,
Respondent number 8.
since the respondent number 8 has been transferred. In view of the above, list the matter after 2 weeks for the learned counsel to take necessary steps. Yes.
Lodge.
Item 3.
Please, Your Lordship.
Yes.
My lord, in this case, we unfortunately require some additional time to file a rejoinder. The reason being is that we have come to, it has come to our attention that in light of the judgment and order passed by this honorable court in a similarly situated case, certain steps have been taken by the government whereby the prayers which are being made in this present writ petition have been given to those beneficiaries. So we would like to place all those things on record. And secondly, their stand is that since I'm working as a ward superintendent at the ZMC, and since ZMC is a society, it cannot be deemed to be under the Health and Family Welfare Department. So for which I need to file an RTI application to get a MOA and all from the concerned
Okay.
department.
So you need more time to
Yes,
file
Your
your rejoinder.
My lord.
Heard Mr. Lalfakoma Ralte, learned,
I'm
no,
not- just
Lalfakoma,
Lalfakoma.
learned counsel for the petitioner, who has prayed for further time to file their rejoinder affidavit, mind mentioning that certain steps have been taken by the respondents. And therefore, he needs to address the steps taken by the respondents in the rejoinder affidavit. Accordingly, list after 2 weeks.
Can it be 3 weeks? Just
Okay,
to be
list
on the
after 3 weeks.
side? Deeply obliged.
Item 4.
Yes. Yes, notice was issued. This is a jail appeal. This is a jail appeal against the judgment and order passed by the Sessions Judge Aizot in Criminal Appeal number 2/2024. In view of the above, this court find it fit to appoint an amicus curiae to represent the appellant. It is seen in this court's order dated 27/08/2024 that notice was duly issued to the respondents and received by the learned additional PP. In view of the above, this court find it fit to appoint Oh, who should we appoint? As amicus curiae. In view of the above, the registry to take steps and appoint an amicus curiae to represent the appellant list in the next week. Yes. List in the next week. Meanwhile, LCR is to be called for.
Item 5.
But please, Your Lordship, I have a hearing at part 2, item number 6. Since the counsel in item number 7 of hearing list did not inform that the matter will be adjourned today. So, my lord, I prepare for that hearing. So, if Your Lordship may
What are
kindly
you
take
talking about? Which item?
part 2 hearing list.
Wait. We have called out an item.
Yes, yes, my lord. Yes, for a hearing list, I prepare for that, my lord. So that if the matter may be taken up on Monday.
Which month?
Next.
Item have you called? Item number 7, part 1.
My learned friend is the respondent in item 7.
Okay. So, yes, so this is an IA.
Yes, my lord.
So why are you saying part 2? There's a part 2 item also?
Yes, my lord, because I mentioned is that I prepare for that hearing. So,
Okay, leave up the item. Let's do
So
7.
be-
Yes.
because
so
my lord, I-
7.
yes, I-
For 7, the present item number 17, you want to pay for adjournment. Is
yes,
it?
my lord, on next Monday.
Let's see.
There's a delay of 525 days.
Mr. Lal Fakoma, learned counsel for the applicant is present, along with Mr. S. Vanal Shiata, learned counsel for the respondent. The learned counsel for the respondent has prayed for adjournment on the grounds that he is not prepared for hearing of the matter today, since he had prepared himself for some other item which was listed today. In view of the above, list in the next week,
21, my lord. Monday.
in next week on 21/10/2020.
Deeply obliged.
Item 8.
Well, this is a case of advertisement issued by the MPSC whereby the reservation for meritorious sport person has not been incorporated in the said advertisement, my lord. So, my lord, by way of this IA 163 of 2024, I seek to amend my writ petition by adding some points, some facts which is necessary for determining
Yes.
the real issue. My lord, in this case,
We have already issued notice.
yes, notice was
So,
issued.
any objection or no? Will allow?
No objection, Your Lordship.
Lordship, I have gone through the IA, so it's more or less of something. Many others facts have been raised. So if you kindly go to
So you want to file a written objection, is it?
actually not filing written objection, my lord.
Then,
I prefer this one. The prayer portion is also it's different. So then he can withdraw with liberty and can file afresh because there are many things to be incorporated.
so if you want to file a written objection on those points, okay, then we'll hear the matter. Isn't it?
Yes, Lordship.
You're simply suggesting that he should withdraw, but why should he withdraw when he has made an I application? Unless you're going to object to it. If there's no objection, then
My
we
lord,
can
that
go
is
ahead.
my oral objection. If the court find this is proper.
Find a written objection in the next date. Okay.
No, in that case, my lord, since my learned friend has submitted that he's not going to file his written objection.
No, are you going to file a written objection or not?
No, my lord, just seeing, if the court feel this is proper, I don't object. We
Okay,
can just
no
accept.
objection, then
Yeah,
we'll
yeah.
allow.
Yes. Because this, the prayer itself are quite of, like a kind of different
No, it's
things.
not
you know.
different.
You really don't have a written objection. If you don't object, then it's okay. We will allow.
My lord, I'll not object. It's a more of submission also.
Okay,
So
fine.
then, if the court allows, then it's fine.
Okay, fine. If they make an application, no objection, we'll allow.
My lord.
Okay. Heard Mr. C. Lal Faghzwala, learned counsel for the applicant, along with Mr. J.C. Lalunsiama,
Alusanga.
Lalunsanga, learned counsel for respondents number 4, and Ms. Lalnun Lui. Is it? Learned government advocate for respondents number 1, 2,
2 and 3.
3. The learned counsels for the respondents submits that they will not be filing any objection to the application made by the learned counsel for the applicant to make certain amendments to the writ petition filed in WPC number 91 of 2024. In view of the above, since no objection has been raised by the learned counsels for the applicants, learned counsels for the respondents, this court find it fit to allow the application made by the learned counsel for the applicant to make certain amendments to the writ petition as follows. Okay. So now it will be in page what? 4.
In para 11 of my writ petition,
So in
para,
page 4 of your application,
yes, my lord.
isn't it?
Yes, my
4,
lord.
5, 6, 7.
So in page 4, this A, okay, this whole thing, then B,
Yes, my lord. Para 13.
C, D,
And the prayer clause,
E.
my
Is
lord.
it? Huh.
My lord.
As follows. Okay, this whole thing you do. Accordingly,
If your lordship permits me, I'll able to file this recast petition within 2 days.
accordingly, since the IA number 163 of 2024 is allowed and disposed of, the learned counsel for the applicant is allowed to make a recast, to submit his recast petition within 2 weeks. Okay, list after 2
I can
weeks.
submit it within 2 days, my lord.
Okay, list after 2 weeks, by which the recast writ petition is to be duly served, also served to the learned counsels for the respondents. Yes.
Obliged, my lord.
Item 9.
My lord, this present application is because on the delay of 311 days to prefer an appeal against the impugned order dated 23rd August 2023 passed by lower court of senior civil just for Aizol in civil suit number 25 of 2016, wherein the lower trial court passed the impugned order rejecting the plaint at the time of hearing on maintainability.
Heard, Mr. Your good name?
Isak Ramdin Thara.
My lord,
Isak.
I will be filing my written objection.
Lal Ramdin Thara, learned counsel for the applicant. This is an application filed under Section 5 of the Limitation Act, Red Bid Order 41, Rule 3 within 3A, okay, capital A, CPC, for condonation of a delay of 311 days in preferring an appeal against the order dated 23/08/2023, passed by the learned civil judge within brackets senior division -4 in civil suit number 25/2016. Notice be issued to the respondents. Yes. Miss Caroline Kela Lungoypu, learned government advocate, accepts notice on behalf of the state respondents. Any private respondents?
Yes, my lord. 7 to 13.
No need to issue formal notice to the state respondents. Notice be issued to the private respondents through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks. In the meantime, the learned government advocate is to file a written objection. Yes,
Much
if
obliged.
any.
Item 10.
Yes.
Lordship, this is a make appeal, and by filing this make appeal, there is a delay of 616 days, Your Lordship. And I have indicates that there is no negligence, there is no intentional or willful negligence on the part of the applicant, Your Lordship.
Okay, will issue notice.
Lordship,
Let's see.
yes.
Yes, heard Mr. Johnny L. Tauchong, learned counsel for the applicant. Full stop. Then this is an application filed under Section 5 of the Limitation Act for condoning the delay of 616 days, is it?
Yes, Your Lordship.
In filing and the appeal against the judgment and award dated 26/10/2022, passed by the Learned Motor Accident Claim Tribunal, Aizawl, Mizoram, in MAC case number 12/2019. Full stop. Issue notice to the respondents. How many respondents?
There are 5 respondents, Your Lordship.
Okay, to the respondents through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks.
So my boss.
Item 11.
Yes,
Lordship, this is an appeal against the order passed by the senior civil judge in heirship certificate number 699 of 2020, that the heirship certificate is issued within 6 days from the date of submitting an application and without giving notice to the appellant.
but you have a application for condonation of delay,
Yes,
isn't it?
yes.
So let's dispose of that first. How many days delay?
882 days.
Anyway, we'll issue notice. Let's see, 800 and something days. So, but Mr. Aldrin Lalomzola, learned counsel for the applicant. This is an application same filed under Section 5 of the Limitation Act for condoning the delay of 882 days in filing the appeal against the impugned order dated 29/07/2020, passed by the Learned Senior Civil Judge -2, Aizawl, in airship case number 699 of 2020. Issue notice to the respondents through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks. Yes.
For hearing, part 2, item number 3.
Yes.
Lordship, today is fixed for my appearance. Actually, this appeal is a kind of the first appeal originated from Lokayukta. This is our very first case where it started right from the beginning, from section 19 till the end. So initially, we filed impleadment application. So that the same was not allowed since there is no provision for impleadment in criminal case. So I was in a very awkward position also. So if I am not, Mizoram Lokayukta is the one who took up the case right from the beginning. And they are the one who directed ACB to investigate the matter. So the state had only little role in that respect. And preliminary inquiry was done. After it came back to Mizoram Lokayukta, and hearing was conducted by Mizoram Lokayukta. And after that, full-fledged investigation was conducted by SCB again by the state. Because as you know, that Mizoram Lokayukta is not having their own agency.
I don't think there's any objection in you appearing.
But my lord, one thing, appearing is one thing, or also being heard is one thing, but being a party is another important thing in criminal case.
So,
Because
no,
there will
you
be
are going to be representing the respondents, isn't it?
My lord, we are not there as one of the respondents at all.
He cannot be. Let us.
So you're going to assess
Assist.
you're going to assess the PP,
Right.
My lord,
isn't it? Both of you, so the PP will be there and we'll also hear you. You are both the PPs.
But I can assist, but that one thing is that whether criminal appeal, wherein active role, even in trial court also.
Since the matter was filed by Lokayukta,
Yes.
so because of that, you being the party who had taken the initial steps, we will hear the Lokayukta as on behalf of the respondents,
Yes.
isn't it? So we'll hear both of you.
Lordship,
What's wrong with that?
One thing is that hearing is important, one thing, but what I would like to say is that even why not including Mizoram Lokayukta as a
State of
one the
Mizoram and another. Who is the other?
that the
Complainant.
complainant, Jerry something.
My lord, if I may, number one, what my learned friend is praying for today has already been decided.
Yes.
That they cannot be made a party this because
No, I'm not-
the RPC does not have any provision for implement. Number one. Number two is that if we go through the provisions of the Mizoram Lokayukta Act of 2014, at section 11,
Let's see. I was under the impression that you'll be assisting the PP.
I was also under that impression.
Then you'll
my
be
lord.
heard together,
My lord,
isn't it? Anyway,
So anyways,
let's see. Section
Section 11.
11.
Yes, that is the constitution of a directorate. And at section 11, subsection 2, may I read, Your Lordship?
Yes.
It says, the director shall, after having been so directed by the Lokayukta, file a case in accordance with the findings of the investigation report before the special court. All necessary steps shall be taken by the public prosecutor appointed by the Lokayukta for
Yes. So he's the
prosecution.
Lokayukta, huh?
So what I'm trying to impress upon this honorable court is that this particular case was filed by the ACB, not the director of the Lokayukta.
We'll have to see to that. Is
what's
it?
it?
So if my learned friend insists on assisting the public the PP, that has already been allowed by this honorable court in that IA. I don't know why my learned friend is pressing on that issue because no appeal has been filed against that order also.
No, my lord, that the reason why I submitted here is that the appeal itself is not maintainable because the necessary party is not made as a one of the parties. Because we are, even if you see the judgment, even if
Okay,
you see,
we'll hear on that matter. Okay.
That is not the issue today.
Do you have any judgments or what? We need to see what is the system out here. So any precedent to rely on something? Give me something.
my lord, one case which was disposed of by this honorable court, wherein, like this case, exactly like this case, and section 19 and also 20,
Yes, yes,
and
okay,
also
whatever.
Vanal Moya case, Mizoram Lokayukta was arrayed as one of the parties, and we took very active role. Even the state council in that case adopted submissions of
I
Okay.
don't
Mizoram-
understand what
Give me those judgments. Okay.
it's been given.
when the Lokayukta was never arrayed as a party in the trial court. This is an appeal.
No, but his submission is that there are other cases decided by a coordinate bench of this court, okay, where Lokayukta was arrayed as a party. So let's see those judgments. Let's see those cases.
My
You
lord,
have
this
to
is-
place
this
before me.
This will unnecessarily delay
My
the
lord,
matter
if you
again.
kindly see the judgment of this case, this present case, if you see the advocate who conducted the trial, even we all
Before the trial
yeah,
court.
before the trial court also.
Before the trial court. So
I
you're saying
am
that-
the one who conducted the trial.
Assisted the PP.
No, if you kindly see the order itself, the body of the cross-examination part, my name is reflected.
No, anyways, now you're saying that such similar matters
Yes,
have already been taken up by this court.
yes.
Okay. Now give me the copy of the judgment of a case, a similar case which has been taken up by a coordinate bench
Yes.
of this court
Yes.
to see whether the same
Whether Lokayukta
system
was made
should
a
be
party.
followed or not, where Lokayukta was made
Made
a
a
party.
party.
We'll
Under
have a
what
look at
provision
that.
would be very interesting.
My juniors are giving me now, and also I can inform the court.
Unfortunately,
My
Okay,
lord,
because
kindly
you have,
see-
because
kindly
you have
see
not
the
been made a party in this case.
Yes.
So Now you're objecting to it. Now, previously there was an impleadment application
That has been
to
decided.
be made a party. So let's look at that IA. Now that IA has been disposed of
Res judicata.
on the grounds that there is no provision to be made an impleadment for an impleadment application to be made in a criminal trial. Now, where's that order? Let's see.
Order dated 21/11/23, passed in IA 56.
So let's read the last part of the order.
Para 13. May I read, Your Lordship? In view of the above, it cannot be said that the applicant has no locus standi in the appeal. However, there is no provision for impleadment in the Code of Criminal Procedure 1973. Be that as it may, it is absolutely clear that the applicant's prosecutor can place its defense in the appeal without being impleaded. The applicant is at liberty to appear and represent the Mizoram Lokayukta in the
Yes.
appeal before the court. They are allowed.
So, this being so, now, if you are unhappy with this IA, now, this is an order which has been passed by this court, the IA. Okay. Now, if there is no appeal against this order, then we have to go as per this order. Now, let's not go back to the thing. Why look into the matter again when it has already been decided?
My lord, this is the order.
That
And
can
also-
only be done in an appeal. You see, he has not filed any review, no appeal, nothing.
So, yes, so in another case, it has been decided like this. And therefore, the step which you have to take is you file a review or you file an appeal
there is no review in
against
criminal-
this. Okay, then you file an appeal against this IA because this IA is regarding this case.
Yes.
Okay, so you file an appeal against this IA saying that this cannot be a correct order because there is cases decided by a coordinate bench, okay, wherein the Lokayukta was made a party, okay, because I cannot say that, okay, then we will make you a party when in this case, this particular case, that issue was decided in this way, in the IA.
My lord, one thing, I understand that, but I admit that there is no impleadment application in CRPC. If
So,
I go for
but-
appeal or review also,
Okay,
And I
but the last portion of this order in
Yes.
the IA, okay, in the last portion of this IA, it has been mentioned that you are at a liberty, okay, to appear and represent Mizoram Lokayukta. So when it has been decided that you can appear and represent Mizoram Lokayukta, now we cannot change this order and so say that, okay, you have to be made a party. So you represent today.
my lord, at least I need to have paper book also. I don't have any things from the court also. And also, if you kindly see the judgment of the High Court, the trial court itself, we all, those who conducted
You
the-
must have made those arguments before when the IWA was decided. I am not here to hear those
Reopen it. Alright. I got it,
submissions
yes.
again because it has already been decided. Okay. Now, since in this case, it has been decided that you can appear
Yes.
if you want on behalf of Mizoram Lokayukta, we'll leave it at that.
Yes.
But if you are unhappy with this IA, order passed in the IA, then you have the option to go on appeal against the IA. And then you can insist that you be made a party as was done in the other criminal cases. Are you getting my point?
Yes, I got it.
Okay. So in
Lordship,
the
at least
instant
I
case,
can raise the maintainability also without impleading Mizoram Lokayukta.
it has been admitted, no maintainability. This has been listed for hearing, isn't
At
it?
least I might be provided paper book
My
also.
lord, if I may, I
So
don't know
if you
why
are not prepared today,
No, I don't have paper book and no documents from the
the
court
IA
itself.
was disposed in November 2023. We're in October 24.
Anyway,
he was well aware of everything. And plus,
We
he's
are
not a
aware,
party.
we are not there in the cause list also.
How can someone who is not a party to the proceedings
You
pray for
cannot be in the
adjournment?
cause list. See, you cannot be in the cause list because you are not made a party. And you are not made a party because the IA has been disposed as such, isn't it?
Yes.
So if you're going to insist that I want to be a party, I want to be there, okay. Now, a paper book you can always obtain from the PP.
Yes.
Since you're not a party, we will not give you a copy of the paper book. And if you want to pray for adjournment today, saying that you are not prepared,
No, my
then
lord.
we'll fix it in the next week.
No, my lord,
No,
that would be
I'm
very
not-
unfair
I'm-
to the applicant.
No, I'm not praying
How can
adjournment.
someone pray for adjournment who's
No,
not even a
see,
See,
party?
because he's saying he doesn't have
No,
a paper
let him
book.
take a copy today and file a written argument.
So, anyway, so
Why should
what?
the matter?
Yeah.
We're just delaying the matter, my lord.
So
no,
can
my
we
lord,
have
I'm
the
not
hearing
praying
today?
adjournment, but I'm just submitting that I can also be heard. Also,
We are going to hear you. We are going to hear you. The IA is disposed of, it says that you can take part. So we'll hear you. That's not the issue. Based on the order passed by this IA, we'll hear you.
Yeah, we
There's
can
no,
have
there's no, okay, so can we go ahead with the case?
Sure, of course.
Okay. Yes.
Well, now that we're settled on that issue. Now, my lord, the present appeal is directed against the judgment and order dated 4/9/23, passed in SRPCA number 1 of 23 by the Court of the Special Judge Prevention of Corruption Act, whereby the present appellant was convicted under 409 IPC, criminal breach of trust, and under section 13(2) read with 13(1)A of the Prevention of Corruption Act 88, that is the criminal misconduct by a public servant. Now, White's sentence order dated 5/9/23. I was sentenced to undergo 2 years imprisonment for violation of the provisions of section 409 IPC, for 2 years imprisonment with 1 lakh fine, ID 6 months, and under section 13(2) read with 13(1)A of PC Act, undergo 4 years imprisonment with 1 lakh fine, ID 6 months. Now, in the present case, Your Lordship, the present case started by submission of a complaint by PW number 1, Mr. H. Thangazote, who was the Deputy Secretary of PWD, wherein a complaint dated 25/2020 was submitted to the Lokayukta.
Okay, page number, complaint is where?
Complaint is at page 155
Of the paper book.
of the paper book. Wherein it was alleged that I had taken some illegal money. Now, accordingly, by acting upon this complaint, the Lokayukta ordered for a preliminary inquiry by order dated 02/06/2020, which is at page 204.
Okay. What is the order?
The order is basically to conduct a preliminary inquiry into the allegations of corruption. So after the preliminary inquiry, Your Lordship, an FIR was finally submitted by one Inspector Jarilalin Sanga on 28/2/2022, which can be found at page 198. This is the
FIR.
FIR, and at page 201. So as can be seen, the complainant is Jerry Larin Sanga, who is from the Directorate of the ACB, not the Lokayukta. Now, I'll just quickly narrate the brief facts of the case as mentioned in the FIR. The allegation is that one contractor, Lalro Enga, who is the PW number 3, resident of Republic Veng, was entrusted with construction and routing maintenance of Rabung Aiduzol Road by agreement dated 5/9/2018. His work order dated 26/9/2018 can be found at page 217.
Page
217.
217.
This is the work order issued by the Chief Executive Officer.
The
So
contract
agreement-
work where?
Construction of Rabung to Aiduzol Road.
Rabung. Okay.
So thereafter, now at that point of time, Your Lordship, I was the supervising JE working under the PWD while I was posted at Khozol. I was the supervising JE. The allegation is that I had allegedly demanded 17 lakhs from the contractor, Lalro Enga, which is the PW number 3. And the second allegation is that I further demanded an amount of rupees 3 lakhs from one Mr. Van Ming Thanga, who is the PW number 4. He was working under Mr. Lalro Enga. And he is referred to as the subcontractor.
Okay, allegation of demanding money.
Right. So there are two issues, two demands. Basically, 17 lakhs from the main contractor, Lalro Enga, who is PW number 3. And an additional amount of rupees 3 lakhs from one Mr. Van Ming Thanga, PW4. During the execution of this Iduzol to Rabung Road. Now, prosecution sanction was issued by the Secretary PWD via prosecution sanction dated 4/11/2022, which can be found at page 180. Yes, Your Lordship.
Okay.
So prosecution was sanctioned. Prosecution sanction was accorded under Section 19 of the PC Act and Section 197 of the CRPC. Thereafter, charge sheet dated 18/4/2023 was submitted, which can be found at page 186. So charges were framed under Section 409 IPC, Section 13(1)(a), (b), and 13(2) PC Act. And as per the charge sheet, Your Lordship may refer to page 190. As many as 20 prosecution witnesses were listed for examination.
Charge sheet was submitted on?
Charge sheet, I don't have the exact date of submission, but the charge sheet is dated 18/4/23.
Okay. Dated, Okay, prima facie case under section 409.
409 and IPC
Read
and
with,
Section 13(1)
13(1) AB.
AB and 13(2) PC Act.
How many witnesses?
20 witnesses, which is at page 190. Thereafter, Your Lordship, if Your Lordship can kindly turn to page 4. Charges were framed on 30/5/23. Page number 4. May I read this from serial number 3?
Yes.
That you, on dated 4/1/2020, being official capacity as JEPWD, committed criminal breach of trust by receiving rupees 17 lakhs from the contractor, Mr. Lalro Enga, and also received 3 lakhs from the subcontractor, Mr. Van Ming Thanga, on dated 19/11/2019, arising out of construction and maintenance of Rabung Iduzol Road, supervised by you, and thereby committed an offence punishable under Section 409 of IPC. Secondly, that you, on dated 4/1/2020, being official capacity as JEPWD, committed criminal misconduct by receiving 13 lakhs from the contractor, Mr. Lalro Enga, and also received 3 lakhs from the subcontractor, Mr. Van Ming Thanga, on dated 19/11/2019, arising out of construction and maintenance of Rabung Iduzol Road, supervised by you, thereby committed an offence punishable under Section 13(2), read with Section 13(a), (b), and (d) of PC Act, and I hereby direct that you be tried in the said so and so. So read over and ask the accused whether he pleads guilty or not, to which pleaded not guilty and claims to be tried. This is dated 30th of May 2023. So the allegation basically is that I had taken rupees 17 lakhs from the main contractor, Lalro Enga, and an additional amount of rupees 3 lakhs from the subcontractor who was working under the contractor. Now, Your Lordship, I would like, with Your Lordship's permission, I would like to start with the evidence, which starts from page 25. Now, evidence will show that, Your Lordship, all the allegations are all false and there's not an iota of evidence against the present appellant which warrants conviction under the said sections of law.
Okay, PW number 1.
PW1 is the complainant, that is the Deputy Secretary of PWD who submitted the complaint to the Lokayukta. May I read, Your Lordship?
Yes.
I'm presently serving as Joint Secretary Finance Establishment since 1/4/2023. I served as Deputy Secretary Higher and Technical Education and LESDE up to 21/3/2023. While I was serving as Deputy Secretary PWD, Engineer-in-Chief PWD forwarded a letter to Deputy Secretary PWD regarding I think it should be siphoning of public money by the accused who was serving as Junior Engineer Western Circle PWD along with the statement of imputation against the accused. The said letter was received by me on 11/5/2020 and the same was processed in file on 14/5/2020 for obtaining approval for investigation from the competent authority. On 15/5/2020, approval for investigation was granted by the Chief Minister in respect of the criminal conduct of the by the accused. On 25/2020, I submitted complaint to Chairman Mizoram Lokayukta requesting to investigate embezzlement of government money by the accused. The complaint was accompanied with statement of imputation against the accused, who served as junior engineer in the office of Western Circle PWD. The statement of imputation was forwarded to me from the office of the Engineer-in-Chief PWD, which was authenticated by me. I'll just skip the exhibits, cross-examination. It is a fact that since 18/3/2020, I am posted in the PWD. It is a fact that statement of imputation against the accused was already enclosed in the forwarded letter which I received from Engineer-in-Chief PWD on dated so-and-so. It is a fact that I did not interrogate the accused when the concerned file was dealt in my aegis. It is also a fact that I did not interrogate the contractor Mr. F. Lal Roenga and subcontractor Mr. Van Huing Thanga, who were also named in the statement of imputation against the accused. I admitted that I came to know the instant cause only on the basis of the letter forwarded by the Engineer-in-Chief PWD. I also admitted that I have no direct knowledge evidence against the accused to reveal his guilt in connection with the instant case. It is a fact that as per the approval of the concerned minister, PWD, we lodged a complaint against the accused in the Mizoram Lokayukta. It is a fact that authenticate, which I mentioned in para 4 of my examination in chief, means not to prove the genuineness allegation, imputation against the accused, but to ascertain the letter, whether it was duly received or not. It is a fact that the bank statement of Mr. F. Lal Roenga and Mr. Rosiam Lana were also enclosed copy, which I received from the office and Engineer-in-Chief PWD, but not connected, recovered by me. I admitted that complaint lodged against the accused in the instant case was not on the basis of my direct knowledge evidence, but on the basis of other sources' documentary evidence. Re-examination. I clarified para number 6 of cross-examination that despite I do not have any direct evidence from the accused, I know that the documentary evidence available to me reveals the guilt of the accused. Further cross. It is a fact that I can ascertain prima facie case against the accused on perusal of materials, circumstances, documentary forwarded by the officer of Engineer-in-Chief PWD. Second is the complainant/informant who filed the FIR, the inspector. May I read, Your Lordship?
Yes.
Page 28. The chairman, Mizoram Lokayukta, directed ACB Mizoram to conduct preliminary inquiry by order number so-and-so. Hence, ACBP number so-and-so dated so-and-so was registered by OCSSP ACB Mizoram and appointed me to conduct preliminary inquiry by order number so-and-so. Accordingly, the matter was inquired into. During the course of inquiry, all efforts were given to find out whether the accused person, Mr. So-and-so, demanded and received money from contractors who were the implementing agency for construction of PMGSY under his supervision. It is found well established that Pusi Lal Fakoma JAPWD demanded and received rupees 17 lakhs from Pulal Roenga, contractor of the work construction and maintenance of Rabung Aiduzol Road, and in his statement, Pulal Roenga stated that the accused demanded him rupees 17 lakhs. In this regard, account transaction detail of contractor Pulal Roenga, ICICI account number so-and-so, and Pusilal Fakoma JPWD SBI account number so-and-so were obtained, and it is found that Pulal Roenga had transferred rupees 17 lakhs in the SBI account of Pusilal Fakoma JPWD on 4/1/2020. Pulal Roenga, son of so-and-so, contractor of the work construction and maintenance of Rabung Aiduzol Road, PMGSY, was examined, and which revealed that Pusilal Fakoma JPWD, who is immediate supervisor of his contract works, had demanded and he had transferred rupees 17 lakhs on 4/1/2020 in the SBI account of the accused Silal Fakoma JPWD via check number so and so on 4/1/2020. It is also found that Van Ming Tang, a subcontractor of Khosol, was examined and which revealed that in the mid-2019, he executed construction of retaining wall in the work Rabung Aiduzol Road under contract work of Pulal Roenga. Van Ming Tang, a subcontractor, received his bill amounting to rupees 21 lakhs from the contractor Pulal Roenga in his SBI account number so and so on 15/11/2019. In this regard, account transaction detail of SBI account number so and so belongs to Pu Van Ming Thang was obtained, and it is found that rupees 21 lakhs was credited in the account of Pu Van Ming Thang, a subcontractor. Pu Van Ming Thang further stated that he had given rupees 11 lakhs to Procedural Fakoma JAPWD. Account transaction details of Pu Van Ming Thang showed that he had actually given rupees 11 lakhs to Procedural Fakoma JEPWD on 19/11/2019. On inquiring as to why Van Ming Thang had credited such amount of money, Mr. Pu Van Ming Thang stated that during execution of subcontract work, he borrowed rupees 8 lakhs from the accused. On receipt of his bill amounting to rupees 21 lakhs, he had given rupees 11 lakhs to Procedural Fakoma JEPWD. Thus, it is found that Procedural Fakoma JEPWD received illegal gratification amounting to rupees 11 lakhs minus 8 lakhs, which amounts to rupees 3 lakhs from the subcontractor Pu Van Ming Thang of Khosol. There is prima facie case that the accused had demanded and taken a sum of rupees 17 lakhs from Pulal Roenga, contractor of Rabung to Aiduzol Road PMGSY, and had taken illegal gratification amounting to rupees 3 lakhs from subcontractor Pu Van Ming Thang. Thus, it is found out and well established that the accused had taken and received illegal gratification amounting to rupees 17 lakhs plus 3 lakhs, which amounts to 20 lakhs. Accordingly, I submitted my inquiry report to the chairman, Lokayukta, Mizoram, and I submitted FIR to OC ACB Police Station and so and so for registering a criminal case against the accused. Pubi Lalhak Liana, Deputy SP ACB, was endorsed to investigate the case. Puh Tang cross-examination. Puh Tang Zateb, Deputy Secretary PWD, was the complainant in the instant case. I have examined the said complainant at the ACB office, but I could not remember the date of his examination. On examination, H. Thangazate stated that he received statement of imputation against the accused regarding embezzlement of government's money from the ENC PWD Mizoram to take approval from the concerned minister. It is a fact that during the course of my inquiry, I did not ask and take statement from the staff of ENC PWD to ascertain the imputation of statements against the accused. I examined Van Ming Thang, a subcontractor of Pulal Roenga, first at Khosol and second at office of ACB Mizoram Aizol, and his statements was recorded at the ACB office Aizol. I also called contractor Lal Roenga at the ACB office Aizol and recorded his statement. It is also a fact that I firstly interrogated the accused at Khosol and second and third was at the ACB office Aizol and recorded his statement. It is a fact that I introduced myself to the subcontractor Van Ming Thang, a contractor Lal Roenga, and the accused Silal Fakuma before I conduct interrogation and recording their statements. It is a fact that during the course of my inquiry, I have obtained bank account transaction details of the contractor Pulal Roenga and the accused Silal Fakuma, and I found that there was transaction of money amounting to rupees 17 lakhs which the contractor Pulal Roenga had transferred to the bank account of the accused by check number 00141 on 4/1/2020. The contractor Pulal Roenga told me that the accused demanded the said amount of money. However, on interrogation, the accused stated before that he had borrowed the said amount of money from the contractor Pulal Roenga. It is a fact that I have not verified whether the reported received money of the accused was borrowed from the contractor Lal Roenga or taking gratification from the said contractor. This is very relevant, Your Lordship. Later on it will come, this will highlight the entire case. It is a fact that I have not verified whether the reported received money of the accused was borrowed from the contractor Lal Roenga or taking gratification from the said contractor. It is a fact that I have visited the work site twice during inquiry and investigation stages, but I could not say its date, month, and year. It is also a fact that I also obtained the SBI account number so and so, Khosol branch transaction details of subcontractor Van Ming Thang. I found that there was bank transaction of rupees 21 lakhs into his account credited by the contractor Lal Roenga, and also found that Van Ming Thang credited rupees 11 lakhs to the bank account of the accused on 19/11/2019. On his interrogation, the subcontractor Van Ming Thang stated that to me that he had borrowed rupees 8 lakhs from the accused for execution of his subcontract works under Pulal Roenga contractor. But he further stated that they had not put their deal of borrowing in black and white. The accused also stated to me that the subcontractor Van Ming Thang used his money for execution of his contract works. However, I have not found this documentary proof from the account of both the accused and Pu Van Minh Thanga. It is not known the transaction between the accused and Pu Van Minh Thanga. It is a fact that the statement of the complainant, which is shown as Exhibit P4, is recorded by me. It is a fact that there is sufficient documentary proof such as copies of account transaction details and copies of check leaves from the complainant, which Thanga Zate. Examination of the complainant alone is found quite satisfactory, and therefore I have not examined the ENC PWD in Mizoram. It is a fact that the inquiry was registered on so-and-so, and I have submitted inquiry report on so-and-so. It is a fact that my statement was recorded by the case IO Pu Bilal Hakliana, Deputy SPSCB. I would like to emphasize on the next paragraph. It is a fact that I have not proved whether the subcontractor Van Minh Thanga borrowed money from amounting to either rupees 8 or rupees 11 lakhs from the accused. He has not verified this fact. It is not a fact that I had not seen a prima facie case against the accused. It is a fact that I do not know, again 19, Your Lordship. It is a fact that I do not know whether the accused Silal Fakuma repaid rupees 17 lakhs to the contractor Lalro Enga or not.
So your claim is that you have repaid the money.
It was borrowed money. Evidence will show that it was borrowed money and they have all been returned.
You have repaid the said
Repaid
money.
Everything is there in the evidence.
Okay. Oh.
So as far as the complainant is concerned, whatever his preliminary investigation, he did not verify all those facts. Now, this is the contractor, PW number 3. His statement is crucial. May I read, Your Lordship?
Yes.
On
He's the main person.
He's the main person. He is the contractor. PW number 3, Lalro Enga, is the contractor. He was issued the work order. On 26/9/2018, I received work order for construction of Rabung to Aiduzol Road, MZ so-and-so under the Executive Engineer Mizoram Rural Road Development Agency. As the Mizoram Legislative Assembly election was to take place, I was bound by the Election Model Code of Conduct, and due to this, I was not able to start construction right away. After the election was over and I was no longer bound by the conduct rules, we started formation cutting in the early 2019. Our work mostly included construction of PCC pavement, retaining wall, slab, Hume culvert, and side drain, etc. Construction of PCC pavement was our main work. I would like to emphasize on this para 2, wherein the contractor highlights the nature of his entire work. So it includes PCC pavement, retaining wall, slab, Hume culvert, and side drain, etc. So the construction of the work included various types of other activities. As our work comprises a lot of raw materials and other accessories, we used to let subcontract initiate the work for taking stones, formation cutting, granular sub-base, collecting sand granules, leveling it, and placing them thoroughly on the roads with a thickness of 4 inch, retaining wall and culvert. It is impossible for us to undertake all the works by ourselves due to shortage of time and manpower. There is never a separate written order, and we casually employed a lot of people to carry out the works for us. My main work was to look after the employees, supply construction materials and machines. I, along with Pukelal Nginglova of Republic Bank, carried out this work. He was the one who started the work initially, and he was also physically present at the construction site. I undertook the work of making appointments in offices at Airol, ordering construction materials from outside the state, and transferring of money. There is a lot of paperwork and bookkeeping. I was not always physically present at the construction site. As far as my knowledge, the accused Silal Fakoma JEPWD is the supervisor of the construction site, and as per my knowledge, Puzo Sanga Zote EEPWD once visited the site. The accused Silal Fakoma did not work as subcontract with us. He was not seeking retaining wall construction work. He was seeking retaining wall construction work for Van Minh Thanga, who was his close friend at the Khozol. We engaged Van Minh Thanga just like we engage everyone else at the request of the accused. I did not know the accused Silal Fakuma JPWD gave special preference to Van Minh Thanga. Van Minh Thanga carried out retaining wall construction at 3 sites. Lordship, this I would like to emphasize. He carried out the work of retaining wall constructions among all the types of constructions and activities that was involved in the contract. We did not make terms and conditions of how much he will earn. After completion of his work, bill was out. After deduction of tax and contractor's share from the bill, I credited rupees 21 lakhs into the account of Van Minh Thanga. As paid by the learned special PP, PW3 is declared as hostile.
Okay.
So he was declared as a hostile witness. It is a fact that we put in a written form for lending and borrowing. I don't exactly know whether this is cross-examination by the special PP, but I will continue. I'm assuming it is. It is a fact that we put in a written form for lending and borrowing rupees 17 lakhs in between myself and the accused. It is a fact that on date 4/1/2020, I transferred rupees 17 lakhs into the SBI account of the accused from my bank account ICICI Bongkon, and it was the day for executing agreement in between myself and the accused for lending and borrowing rupees 17 lakhs. It is a fact that we did not have any witness. We did not have witnesses for executing agreement in between myself and the accused for lending and borrowing rupees 17 lakhs. It is a fact that there was no stamp duty as well as other legal provisions compliance for executing agreement in between myself and the accused for lending and borrowing rupees 17 lakhs. It is a fact that the accused did not tell me purpose for borrowing 17 lakhs from me. It is a fact that there was no agreed interest for lending rupees 17 lakhs to the accused. The accused already liquidated his borrowed amount to me in 2021 due to outbreak of COVID-19. He liquidated the same lately. It is a fact that the accused transferred his borrowed amount to me from SBI main branch, Aizawl, for twice at the rate of rupees 9 lakhs and rupees 8 lakhs to my bank account in ICICI Bongkon branch. I admitted that the accused liquidated his borrowed amount to me after the instant case was registered in Mizoram Lokayukta. It is a fact that before registering the instant case in Mizoram Lokayukta, I did not ask and also did not serve legal notice to the accused for repayment of his borrowed money. It is a fact that I never give any amount to the accused in connection with the instant contract work. This is very important, Your Lordship. It is a fact that...
Wait, serial number 18, if it is a fact, then the suggestion is that he never gave any money. Is it the way it has been recorded?
My interpretation, my interpretation of this particular sentence is that the contractor did not give the accused any money out of the contract work. Whatever he gave was from his personal kitty.
So that's what. So if serial number 18,
Yes,
the
madam.
question, if it's a cross-examination, then the prosecution is also admitting that they never gave any money. Is it?
It seems so, my lord. So
The
no
nature,
amount,
18.
yes. So no amount was given to the accused.
That's what the prosecution is also admitting,
Yes,
because it is a fact.
it is
So-
a fact. So I
Or
admitted.
maybe it's wrongly recorded. I mean, the prosecution should not ask such a question, make such a suggestion.
But fortunately or unfortunately, it is there on record,
Okay.
and that cannot be ignored anymore. I admitted that I did not produce and show puisa in pugna between the accused and myself to the case IO and inquiry officer. It is a fact that though I stated to the case IO and inquiry officer that the alleged corrupted money at rupees 17 lakhs was a borrowed money, they did not demand me to produce a deed for puisa in pugna. It is a fact that I do not know whether or not the accused withdrawn his GPF amount to repay his borrowed amount at rupees 17 lakhs. It is a fact that we executed puisa in pugna in my residential house. It is a fact that I do not know the date for executing puisa in pugna was public holiday or Sunday or Monday, etc. It is a fact that I have a small office in my residential house possessing computer machine, both laptop and desktop, Xerox machine and printer machine but I do not know the company name of my printer machine. It is a fact that I do not know whether or not I remain with a original copy of puisa in pugna. It is a fact that my family members, including me, consist of 7 numbers, but I do not obtain my family members as witness for executing puisa in pugna. It is a fact that my educational qualification is below class 10, but I can use, including typing, computer machine to meet my requirement. Puisa in pugna is also typed and printed by me. So he is stating that everything was done by him. I deny the suggestion that I did not disclose the alleged involved amount was borrowed money before the institution of the instant case. It is a fact that the last time for communication with the accused was today at around 2 a.m. and second last time was just before receiving court summons to witness to me, but I do not know the exact date. We do not have any other frequent communication crossed by the defense. It is a fact that since the year 1989 till date, I used to execute government contract work, but in others' name at initial till I was enrolled as government contractor. It is a fact that I fully completed the instant contract work in between Rabung and Aiduzol under PMGSY. It is a fact that I also have many other subcontractors in the instant contract work apart from Mr. Van Huing Thanga. I would like to stress on this particular sentence to show that Van Minh Thanga was a subcontractor under Mr. Lalro Enga. It is a fact that in my remembrance, the accused supervised my contract work during 2018 to the end of 2020. It is a fact that the accused never insisted and obtained an amount from us during execution of contract work under his supervision. It is a fact that the accused asked me to lend rupees 17 lakhs. I therefore voluntarily lent the same to the accused. The accused already liquidated the said amount to me. It is a fact that Puisa in Pugna, which I produced on today, is not fabricated and false and was a genuine document. It is a fact that borrowing 17 lakhs and repayment of the same in between the accused and myself was cashless, that is bank transaction. It is a fact that I am stated in this court on today is true and correct. So what appears from the statement of the contractor is that it was a borrowed money and it was his personal money and it was not out of the money which was received from the contract work. Basically, in other words, to say that it is not a government money. It was not a public money. Now, PW number 4, Your Lordship, which is at page 37, is the subcontractor. So the second charge, the allegation in the second charge is taking off illegal gratification of rupees 3 lakhs from this particular witness. His name is Mr. Van Minh Thanga. May I proceed, Your Lordship?
Yes.
I was born and brought up at Sampai Zote. I, along with my families, moved to Kozol in the year 1975 because of my father's work. I, with my family members, are residing at Kozol till date. In mid-2019, contract work for construction of Rabung to Aiduzol Road under the supervision of PWD accused Silal Fakoma J.E. Pulal Hinglova, manager of contractor Pueflal Road Enga. I sought for subcontract work and I carried out the subcontract work for construction of retaining wall at 3 different places. Retaining wall. The bills for the construction work amounting to rupees 21 lakhs was transferred by the contractor F. Lal Roenga to my SBI account number so-and-so on so-and-so day. I did not submit any application for subcontract work at PWD. I did not submit any application for subcontract work at PWD. I requested Ms. Pulal Hinglo, manager of FLL Roenga, to let myself and the accused Silal Fakoma to carry out subcontract work. After I received permission, I, along with the accused, went to inspect the site for construction, and thereafter I initiated the construction of the retaining wall at 3 different sites. While I was working as a subcontractor under FLL Roenga, the work supervisor was Pulal Hinglo, Republic Veng Aizol, while I was working as a subcontractor under FLL Roenga. Under FLL Roenga, the subcontract work which I undertook was construction of 3 retaining walls. The bill amounting to rupees 21 lakhs was transferred in my account by Pulal Roenga on so-and-so. After this, I worked as material supply recorder for about 1 month and a week. I earned rupees 30,000 for this particular work. When the accused Silal Fakoma was posted here at Kozol, he befriended me and we became close friends. I was able to carry out the construction of the 3 retaining walls because the accused also requested Pueflal Roenga to give the work to me. In order to carry out the construction work, I was not having the capital, so I borrowed the accused money amounting to rupees 8 lakhs for completion of the work. On 15/11/2019, contractor Pulal Roenga transferred rupees 21 lakhs in my account for completion of the work. Thereafter, I transferred rupees 11 lakhs to the accused Silal Fakoma's account from my account number so-and-so on 19 and so-and-so. In this connection, in addition to rupees 8 lakhs which I borrowed from the accused, I later borrowed rupees 3 lakhs from the accused as my construction work was expensive than I expected. So, the 3 lakhs, which is the allegation, the subcontractor is stating that this is the additional amount which he had taken from the appellant. And as such, when he received his bill, he had repaid a total amount of 11 lakhs. That is 8 lakhs initially taken plus the 3 lakhs which was subsequently taken. As paid by the learned special PP, PW4 is declared as hostile. Cross-examination by the learned special PP. It is a fact that there was no written deed for borrowing rupees 3 lakhs from the accused apart from the previous borrowed amount of rupees 8 lakhs. It is a fact that I do not know the date for borrowing rupees 3 lakhs from the accused apart from the previous borrowed amount of rupees 8 lakhs. It is a fact that during the beginning of 2019, I borrowed rupees 8 lakhs from the accused. It is a fact that for borrowing 3 lakhs from the accused, I was handed over in cash by the accused in his residential house at Kozol. However, no other persons were available at the time of the said transaction. It is a fact that the accused did not insist me to repay rupees 8 lakhs by any means which I borrowed from him. It is also a fact that the accused did not insist me to repay rupees 3 lakhs by any means which I borrowed from him. It is a fact that the police interrogated me in the inspection bungalow at Kozol. I know that name of police officer who interrogated me was Mr. Jerry. It is a fact that I also informed to the police officer who interrogated me about borrowing rupees 3 lakhs from the accused apart from the previous borrowed amount of rupees 8 lakhs. This was never recorded in the FIR.
Okay.
It is a fact that I did not ask the investigating team to make correction changes of my statement. It is a fact that, being a close friend, even after receiving summons to witness, I was also contacted by the accused. It is a fact that the accused also informed me that my statement recorded by the police was like bribe corrupted money of rupees 3 lakhs, not mentioned that it was borrowed money. It is a fact that I also asked the accused the date for borrowing rupees 3 lakhs from him, but we were not ascertained. It is a fact that I do not know the money which I repaid to the accused was before or after registration of a case in the Lokayukta. Defense cross. It is a fact that subcontract work which I executed was about 44 kilometers from Kozol. It was a new formation cutting of road. It is a fact that I do not know who accompanied police officer Mr. Jerry, who interrogated me in inspection bungalow at Kozol. It is a fact that at the time of physical interrogation at inspection bungalow Kozol, it was recorded by handwritten. It is a fact that I do not know whether the case I am Mr. Bilal Hapliana also came to Kozol or not. It is a fact that ACB personnel also brought to the place of work which we executed by the. I do not know other ACB personnel except Mr. Jerry. It is a fact that I was also interrogated at the ACB office. In my knowledge, it was again Mr. Jerry. It was also done by a handwritten. It is a fact that I do not have adverse remarks upon the accused, even during execution of our work at Kozol and under his supervision. It is a fact that I firstly borrowed 8 lakhs from the accused for the execution of my subcontract. As it was insufficient to complete the work, I again borrowed another sum of rupees 3 lakhs from the accused for the same purpose. So, the fact of the matter is, Your Lordship, whatever amount was alleged to be misappropriated, it has been returned. So there is no illegal gratification whatsoever as far as the statement and evidence of the subcontractor, that is PW number 4, is concerned. Now the next few witnesses, with Your Lordship's permission, at page 41 onwards, I would like to skip because they are mostly seizure witnesses. Quite a number of seizure witnesses, my Lord.
PW number 52, PW number?
I'll PW number 5 to 17, my Lord.
17.
17.
What was seized?
These contract documents, my Lord. The contract documents, bank transaction details.
Okay.
In the list of witnesses at page 190, it's already mentioned.
Okay.
Who are the seizure witness? So and so. So straight away, I would like to take Your Lordship's attention to page 70. This is the officer who gave the prosecution sanction.
Yes.
Page 70. This is one Mr. Kelal Thom Moya. May I read, Your Lordship? I belong to 1991 batch of MCS. I was posted as secretary to the government of Mizoram PWD since June 2022 till date. During my tenure there was an allegation against Mr. Silal Fakoma Junior Engineer PWD Western Circle to have committed criminal breach of trust and also misconduct by misuse of his official capacity and power. In this regards, criminal case by ACB PS case number so-and-so was registered against Mr. so-and-so. Thereafter, the government received an application for prosecution sanction for prosecuting Mr. so-and-so before the court of competent jurisdiction and under the aforementioned section of law. After careful scrutiny of the application, along with the documents supplied with the petition, in my opinion, the case is genuine and there is prima facie case against Silal Fakoma, son of so-and-so, to be prosecuted. Accordingly, prosecution sanction is accorded as provided under section 197 of the CRPC and section 19 of the Prevention of Corruption Act 1988 and issued prosecution sanction order memo number so-and-so dated 4th November 2022. Since the accused is Group B non-gazetted, appointing authority is secretary to the department concerned, and I am therefore competent to accord prosecution sanction. So prosecution sanction is exhibited as Exhibit P11. Cross-examination. It is a fact that I received the concerned file for prosecution sanction on so-and-so put up from the Joint Secretary PWD. I also know that the said file was put up to the desk of Joint Secretary from Deputy Secretary PWD. It is a fact that we received letter for initiation of the case from the Office of the Engineer-in-Chief PWD under the signature of Deputy Director PWD. It is a fact that Office of the Engineer-in-Chief PWD received proposed letter for prosecution sanction from Mr. B. Lalhakyana. It is a fact that though I know the name of the accused, that is so-and-so, in the Western Circle at the relevant time, but I have not yet meet him personally. It is a fact that name of contractors and subcontractor pertaining to the instant case was not mentioned in the prosecution sanction letter. Prosecution sanction letter further did not disclose the amount of alleged corrupted amount. It is a fact that before according prosecution sanction, I did not interrogate the contractor and subcontractor concerned. It is a fact that I know from the case history that the accused used to insist bribe money from the contractors and also used to prepare exorbitant bills estimates in the contract work. It is a fact that my prosecution sanction also did not disclose name of the contract work as well as place of contractual work. Further, it is also did not disclose the PWD division concerned. It is a fact that PWD Western Circle, which I mentioned before, is meant the posting place of the accused and at the time of according prosecution sanction. It is a fact that the material circumstances which I perused before issuing prosecution sanction were ACB papers, previous complaint letter submitted to Mizoram Lokayukta against the accused, processed in the relevant files, etc. For that, I have gone through such papers documents for one time only. I, therefore, find prima facie case against the accused. It is a fact that the complaint against the accused in connection with the instant case was lodged in Mizoram Lokayukta before I hold the post of Secretary PWD. It is a fact that I myself did not give opportunity of being heard upon the accused. Opportunity was not given as required under Section 19. As it was not a matter of disciplinary proceedings and as other authorities concerned already heard the accused, I did not give opportunity of being heard to the accused. Para 12, Your Lordship. This is in violation of Section 19 of the Prevention of Corruption Act. I deny the suggestion that I did not go through the provision of Section 19 of the PC Act before according prosecution sanction against the accused. I admitted that para 14, Your Lordship. I admitted that I did not give opportunity of being heard to the accused in terms of second proviso under Clause C, subsection 1 of Section 19 of PC Act. So there was irregularity in according the prosecution sanction. This is one of our grounds of appeal. It is a fact that I did not take legal advice consultation for granting prosecution sanction against the accused. It is a fact that for quoting Section 197 CRPC and Section 19 of PC Act in the last paragraphs of prosecution sanction against the accused, I also peruse the relevant provision of law. But in this moment, I cannot explain the elements, ingredients under Section 197 CRPC and Section 19 of PC Act. It is a fact that I am also unable to say the provision of Section 409 IPC at this point as well as Section 13 of PC Act. It is a fact that in my knowledge, being Secretary to the Government of Mizoram PWD, I am competent authority for appointment and removal of the accused being JAPWD, but I am not sure on that legal implication. It is a fact that though I issued prosecution sanction in the name of the Governor of Mizoram, as per the relevant provision of Mizoram Transaction of Business Rules, the concerned matter was put up with the approval of the Chief Minister, but no need to put up the matter to the aegis of Governor. As embodied by the said Mizoram Transaction of Business Rules, we formally issued prosecution sanction in the name of the Governor. It is a fact that I never accorded prosecution sanction apart from the instant case. I deny the suggestion that an instant prosecution sanction was not accorded in my own prudence and knowledge. I deny the suggestion that I did not apply my mind for according prosecution sanction in the instant case. I also deny the suggestion that ACB already authored prosecution sanction matter and therefore blindly subscribed my signature therein. It is a fact that in my knowledge and understandings, it is the discretion of the authority concerned to accord or not to accord prosecution sanction as the case may be determined. It is a fact that though subcontractor was embodied in the prosecution sanction letter, in my knowledge, there was only one subcontractor. It is a fact that I accorded prosecution sanction on 4/11/2022. It is a fact that the case IO did not record my statement. So, Your Lordship, our humble submission so far as this particular witness is concerned is that there was clear violation of Section 19, second proviso of the PC Act while according the prosecution sanction. Now the next witness is the IO, Mr. B. Lalhakliana. On 25/2020, Sri H. Thangazate, Deputy Secretary PW Mizoram, submitted complaint to the chairperson Mizoram Lokayukta to investigate the alleged illegal money taken by the accused Silal Fakoma JEPWD from contractors while he was posted at Kozol subdivision. The chairperson Mizoram Lokayukta directed ACB to conduct preliminary inquiry by letter number so and registered preliminary inquiry number so after getting government approval from Chief Vigilance Officer Mizoram Aizol. SP ACB entrusted Inspector Jarilal Sanga ACB to inquire into the report. During preliminary inquiry, Inspector Jarilal Sanga substantiated the allegation with the following points. 1. Srilal Roenga Republic Bank was appointed to construct Rabung to Idizol Road MZ0 so and routing maintenance for 5 years after completion of construction under PMGSY. Agreement number so by letter number so dated 20th September 2018. The inquiry revealed that the said accused, Silal Fakoma JEPWD Kozol Division, demanded illegal money from the appointed contractor Lal Roenga, amounting to rupees 17 lakhs and rupees 3 lakhs from Ban Ming Thanga, who was working under Lal Roenga contractor as subcontractor. The allegation was substantiated and Inspector Jarilal Sanga submitted FIR to the SP-ACB with a request to register a case against accused Silal Fakoma JE. Hence, SP-ACB registered ACB-PS case number 1 of 2022 dated 28/2/2022 under section so and entrusted Pubi Lalhakliana, Deputy SP-ACB to investigate the case. Since Ms. Pubi Lalhakliana so was repatriated to Home Department by memo number so, I was entrusted to continue the investigation by order number so. Hence, I investigated the case. During investigation of the case, I examined and recorded statement of the following persons among other witnesses. Sri Thangazate, accused Silal Fakoma Lal Roenga, and Ban Ming Thanga. On 7/3/2022, 21:30 p.m., I seized 2 numbers of passbooks bearing account number so of SBI at the office of ACB on being produced by accused Lal Fakoma JEMPWD in presence of Lal Nunmoya so in not so in Rangsanga so. On 29/4/2020, I seized the following document on being produced by so. I'll just skip this. This all this leisure. See transaction. See para 10 onwards. My investigation revealed that Silal Fakoma was transferred and posted to Kozol subdivision from Kolkul subdivision to look after the works of construction and maintenance of Rabung Iduzol Road exhibit so. Is the transfer. During his tenure at Kozol subdivision, accused Silal Fakoma was assigned to supervise and look after the following works of PMGSY under Kozol Division and Kozol Subdivision: construction and maintenance of the Bungay-Dizol Road, construction and maintenance of Kozol-Ngayzol Road. Hence, prayer for prosecution sanction was submitted and the Secretary of Government of Mizoram PWD issued prosecution sanction order against Mr. So-and-so to prosecute Srilal Fakoma JE PWD Western Circle. Before I submit charge sheet, I was transferred to 3rd Battalion MAP and the case was continued and charge sheeted by Mr. R.L. Nunmoya DSP SCP. Cross-examination is at the next page. It is a fact that as instructed by his superior officer, the complainant, namely Mr. H. Thangazate, Deputy Secretary PWD, submitted a complaint, but I cannot specify his superior officer who instructed to do the same. It is a fact that as per interrogation with the complainant, he merely stated he submitted a complaint on the basis of receiving instructions from his superior authority. It is a fact that the date for commencing my investigation be revealed by the date for receiving FIR. It is a fact that I also visited the PO where the case was acted out on 5/5/2022. For that, the subcontractor, Inspector Jarilal Sanga, one constable, but not remember his name, and my driver accompanied me. It is a fact that, in my knowledge, interference of the inquiry officer after submission of preliminary inquiry report for further investigation of the case is lawful and permissible. It is a fact that I interrogated the contractor Lal Roenga in the ACB office, but not remember number of interrogations of the said Lal Roenga. It is a fact that during recording statement of Mr. Lal Roenga, he was also present and was done both by handwritten and computer typing. It is a fact that the contractor, Mr. Lal Roenga, did not state to me that he lent the involved money to the accused. It is a fact that I interrogated the subcontractor, Mr. Van Ming Thanga, at Counsel for once. I deny the suggestion that the statement of Van Ming Thanga was fabricated in as much as he stated that Inspector Jerry Lalrin Sanga recorded his statement by handwritten. In this connection, I state that by declining his statement recorded by Inspector Jerry Lalrin Sanga, I recorded his statement afresh. It is denied by me we fabricated statement of Mr. Van Ming Thanga by manipulating his previous handwritten statement. It is a fact that I interrogated the accused in SCB office but not remember how many times. It is a fact that without any assistance, I interrogated the accused. It is a fact that the inquiry officer himself prepared his own statement. I therefore did not separately interrogate him. It is a fact that there are other public offices nearby the SCB office. It is a fact that due to non-availability of reliable local residents, without obtaining the independent civilian witnesses, seizure in respect of 2 bank passbooks were seized on 17/3/22 at so-and-so time. For that, we did not obtain any other independent witness from the office nearby the SCB office. I also did not ask my subordinate staff to ponder independent witness from the office nearby the SCB office, as it was only seizure of 2 bank passbooks, which were not very vital to the case. Same as with seizure of letter and bank documents from Mr. Lal Roenga, contractor, on 29/4/2022. It is a fact that the seizure memo in respect of the seized of letter and bank documents from Mr. Lal Roenga, contractor, was prepared by seizure witness Mr. So-and-so. It was a fact that she was nearby the place of preparation of seizure memo without presence of PW8. I admitted that in the statements of 2 seizure witnesses, namely Mr. So-and-so and Mr. So-and-so, a reason for using police personnel as seizure witness was not included. I admitted that in respect of, it's basically about seizures, my lord. Can I skip to the next page?
So you're not denying the fact that you had taken money,
I taken money. I
but
borrowed.
that you borrowed it. So
Yes.
the seized bank accounts, etc., that has not been denied.
That is not
It's
denied.
admitted. It's all part of this thing.
In
Yes.
fact, Your Lordship, I am a JE by profession, and I have undertaken a lot of supervision. If I was to take a bribe from anyone, why would I leave a trail behind by allowing such transaction to happen online, which can easily be tracked by anyone? Number one. Number two is that, Your Lordship, as I had mentioned earlier, or whatever amount that I had borrowed from the contractor and the subcontractor was not out of the contract work. These were all their personal money.
Okay, but when you say
17 lakhs was borrowed by me from the contractor, but rupees 11 lakhs was borrowed from me by the subcontractor, which he later on returned.
Okay, but when you say that you returned the money in your bank transaction, does it reflect?
Yes,
Do you
ma'am.
did you produce the evidence?
Yes, it's there. It's there.
Okay,
In fact, as far as this 17 lakhs is concerned, my lordship, the charge that was framed, the first charge that was framed for taking illegal gratification of rupees 17 lakhs, the trial court had held that the prosecution failed to prove their case, in fact.
Okay, anyways, let's
Yes.
go ahead.
So,
Let's
and
finish the evidence.
yeah, this is the last one. This is the officer who had actually submitted the charge sheet because the previous incumbent had been transferred. Shri H. Thangazate, Deputy Secretary, page 84, Your Lordship.
Yes.
Shri H. Thangazate, Deputy Secretary, PWD, Mizoram, submitted complaint to the chairperson, Mizoram Lokayukta, to investigate the alleged illegal money taken by accused Cyril Fakuma JPWD from contractors while he was posted at Counsel subdivision. Chairperson, Mizoram Lokayukta, directed ACB to conduct preliminary inquiry by number so-and-so, so-and-so. After getting approval from Chief Vigilance Officer, it's basically a repetition, Your Lordship. Anyways, I'll continue. Para 2. The allegation was substantiated, and as such, Inspector Jerry Lalrin Sanga submitted FIR to the SP-ACB with a request to register a case against accused Cyril Fakuma JPWD. Hence, SP-ACB registered ACB-PS case number so-and-so under section number so-and-so and entrusted to B. Lalmhap, Deputy SP, to investigate. During investigation of the case, B. Lalmhap seized several documents, and also he examined witness and recorded their statement. However, before he submit charge sheet, he was transferred to 3rd Battalion MAP, and I was entrusted to continue the investigation by order number so-and-so. I've gone through all the documents seized by the previous IO and also produced statement of witnesses as well as the result of the investigation. I therefore concluded that the finding of the previous IO is reliable and is as it based on documentary as well as verbal evidence of witnesses, and then I submitted charge sheet under section 40900 with 13(1)(a), (b) and 13(2) of PC Act amended against Friedel Fakoma. So these are the exhibits. Para 20 and page 86 is the cross-examination. It is a fact that I do not know the accused in the instant case. I did not see him even during the course of my investigation. It is a fact that I ascertain the nature of emergence of the case. It is a fact that in my knowledge, the case was initiated by the government, but I am unable to specify the particular authority concerned who initiated the case. It is a fact that I took up the case as case IO with effect from so and so, and therefore submitted charge sheet on dated 10/4/2023. I therefore took up the case as case IO only during 12 days. So he was there only for 12 days.
He doesn't know anything.
Yes, Your Worship. I'll continue, and nevertheless. As the case was initially registered by the Mizoram Lokayukta and submitted charge sheet through Mizoram Lokayukta, in the front page of the charge sheet, I put Special Judge PC Act for Mizoram Lokayukta. It was done as per instruction which we received from our superior authorities. It is a fact that I cannot say pending investigation cases which were directed by Mizoram Lokayukta, but I know there are 5 cases which were already finished investigation and submitted to Mizoram Lokayukta for their consideration. It is a fact that the ACB were not under the purview of Mizoram Lokayukta Act. It's a fact that ACB were not under the purview of Mizoram Lokayukta Act. Meanwhile, we also followed the provision of the Mizoram Lokayukta as the case may determine, namely, initial registration of cases, direction for preliminary inquiry, mode of preparation, submission of charge sheet, etc. It is a fact that for the purpose of prosecution sanction, we follow the provision of relevant acts apart from Mizoram Lokayukta Act. It is a fact that I know points, grounds of allegations against the accused. It is a fact that I did not visit the place of road construction pertinent to the instant case. It is a fact that we obtained prosecution sanction under PC Act and CRPC against the accused. It is a fact that at the stage of my investigation, as the case, no new seized documents and also no record of statements of witnesses, including the accused. It is a fact that except material evidence already collected by the previous case IO, I did not have any direct evidence against the accused. I deny the suggestion that I did not classify investigation part already done by the previous case IO and myself. It is a fact that apart from bank account statements and check, no formal seizure memo were made in respect of exhibited documents as they were simply collected. Such documents were collected by the previous case IO. It is a fact that I found a prima facie case against the accused on the basis of material circumstances already collected by the previous case IO. It is a fact that before I sum up of the case being the later case IO, I consulted the previous case IO by a telephonic message. It is a fact that I did not obtain my assistance as the case IO in the instant case, but I do not know that the previous case IO obtained the same or not. It is a fact that the previous case IO already authored, prepared charge sheet and submitted to Mizoram Lokayukta for their consideration. After returned the same to the ACB, as I was re-endorsed to take up the case as case IO, before I finalized charge sheet, I meticulously examined the contents and circumstances and make necessary changes. After that, I finalized the instant charge sheet papers. This fact that I don't know whether or not Mizoram Lokayukta is having a separate investigation wing agency apart from us, ACB. So those are the evidences that have been recorded. Now, coming to the judgment and order, which is at page 89, Your Lordship. I will not read the entire judgment, but I would like to take Your Lordship's attention to page 92. So, 3 points for determination were framed. One is whether there was any irregularities. So, it was held that there was no irregularity in the prosecution of the case. Although we are saying that there is in this present appeal, because when the prosecution sanction was accorded, opportunity of being heard to the accused was not given as required under section 19, second proviso of the Prevention of Corruption Act. This is a fact admitted by the author of the prosecution sanction. That his statement was there. So as such, in our humble opinion, there was irregularity in the prosecution of the case in the first place, and if opportunity of being heard had been provided.
Let's see, section 19. What does it say, the language? Shall, may, what? PC Act.
Your Lordship has section 19.
Wait. What is the language use? Is
Shall.
it shall?
The language, the choice of word is shall. Second
Okay.
proviso. Your Lordship has it? Sorry, I'll wait.
Yes.
Second proviso at the bottom. Provided further that in the case of request from the person other than a police officer or an officer of an investigation agency or other law enforcement authority, the appropriate government or competent authority shall not accord sanction to prosecute a public servant without providing an opportunity of being heard to the concerned public servant.
Okay.
So that is one of our grounds of appeal, to the effect that if the opportunity had been granted, there is every possibility that this entire prosecution could have been avoided, and the appellant could have satisfied the concerned authority. And number two is this: whether or not the accused Mr. Silal Fakoma, in the capacity of JPWD, committed criminal breach of trust and criminal misconduct by dishonestly demanding and receiving a sum of rupees 17 lakhs from the contractor Mr. Lal Roenga working under him, which is transferred from his ICICI bank account number so and so to the SBI account number so and so of the accused on 4/1/2020, and it is liable to punish under 409 IPC under section 13(2) read with 13(1)A and B of PCR 1988, if so, to what extent? Now, in this respect, I would like to take your Lordship's attention to
Whether he demanded money. Isn't it that
Yes.
point?
at para 33 of the judgment and of the order, in the internal numbering. Paper book page 104. Paper book 104, para 33. Your Lordship has it? In other words, a very stern disciplinary proceedings may be suited and appropriated, but the prosecution fails to prove criminal act of the accused under this point. So we are now basically concerned with point number 3.
Okay, proved under this point. So para 33 is discussion of issue number 2, is it?
Yes, Your Lordship, regarding that 17 lakhs. The first one is regarding irregularity. Second one is the 17 lakhs taken from the
Okay,
contractor.
97 says point number 2. Page 97 mentions it is point number 2, and 33 is the
Finding.
conclusion, finding.
Yes.
Okay.
So as far as point 2 is concerned, that was dispensed with. Now, as far as point number 3, I'll just read I'll just rely on page 104 onwards, Your Lordship. Whether or not the accused Mr. Silal Fakoma, in the capacity of JFE, PWD, committed criminal breach of trust and criminal misconduct by dishonestly demanding and receiving a sum of rupees 3 lakhs out of 11 lakhs from the subcontractor Mr. Van Ming Thanga working under him, which is transferred from his SBI account number so and so to the SBI account number so and so of the accused on dated 19/11/2019, and it is liable to punish under section 409 of IPC and section 13(2) that with 13(1)A and B of the PC Act 88, if so, to what extent? So the allegation under charge number or point number 3, or should I say charge number 3, is regarding this 3 lakhs. Whether I took illegal gratification of rupees 3 lakhs from this subcontractor, Mr. Van Ming Thanga. So there is a lot of reproduction of the evidences. With Your Lordship's permission, I would like to take Your Lordship's attention to para 40, page 108 onwards. Your Lordship has page
Yes.
108, para 40. It is therefore crystal clear that the accused arranged subletting of some contract work allotted to Mr. Lal Roenga to Mr. Van Ming Thanga, namely construction of 3 retaining walls in the road construction, It is also further clear to say that the said subcontractor is a close friend of the accused, where the accused was lodged in his residential house at Khozol. Whether such act of accused is lawful or not is the first question. Relevant provisions of the Central PWD Manual 2014, published by the Director General, Central PWD Works Department, Nirman Bhawan, is excerpt as below. Number one, there is no allegation regarding violation of PWD Manual 2014. Number two, this Central PWD Manual was never exhibited. It was never made part of the records. In any event, what the learned trial court has relied on is this clause 33.13 subclause 2, I think, which has been underlined. Permission to sublet or assign the contract or contract to another party should not be given to a contractor under clause 21 by the divisional officer without prior reference to the authority who accepted the tender. So these are the do's and don'ts of basically subletting of contract work. But at the bottom there is a note. This is an exact reproduction of this clause 33.13. At the note, engagement of labor on a piece of work shall not be deemed to be subletting. In the present case, PW number 4 was engaged by the PW number 3 for execution of only one piece of work. That was construction of the 3 retaining walls amongst all the other activities which form part and parcel of the contract. So the construction of retaining wall was only part of the entire contract which required cutting of earth, construction of hume pipes, drain pipes, so and so. So even if this particular clause was to be invoked, the proviso would still come into play in the present case.
Okay.
So it goes on to say that from para 41, it denotes that the accused being JE, PWD is not accepting authority of the said tender. Therefore, any subletting of contract work at his own level is illegal. Moreover, the so-called subcontract sublettee, Mr. Van Mingtanga, PW4, is indisputably not a contractor equivalent or above the contractor, Mr. Lal Roenga. The accused is therefore liable to convict under 409, criminal breach of trust, as settled proposition of law. Now, where is the 3 lakhs we're talking about? Charge was framed for illegal gratification of rupees 3 lakhs. Nothing to do with subletting or deviation from the PWD manuals. Then there's case record, and I will just skip para 42 because this is basically reproduction of section 13 of the PC Act, just for the time being. And at para 43 is the finding and the conclusion. Para 43, page 110.
So what is the finding?
As per deposition of PW4, Mr. Van Mingtanga, who was the sublettee subcontractor and admitted by the accused in his examination under section 313 CRPC, the accused being JEPWD, who supervised the contract work executed by the contractor, Mr. Lal Roenga, lodged in the residence of his close friend, Mr. Van Mingtanga, on knowing the poor financial position of the said Mr. Van Mingtanga. The accused, being an authority to initiate bills for payment upon the contractor, Mr. Lal Roenga, arranged subletting the contract work of Mr. Lal Roenga in favor of Mr. Van Mingtanga worth rupees 21 lakhs. Expenditure for the said subcontract work was work stated by PW4 and the accused in his examination under 313 CRPC is 11 lakhs. Lent by the accused to Mr. Van Mingtanga. This has also revealed that the profit of the said subcontract work, if at 10 lakhs, which is very exorbitant rates amount detrimental to public interest, the dishonest and fraudulent act of the accused for subletting the said contract work in contravention of the force of the in-force Central PW Manual 2014 to his close friend Mr. Van Mingtang also amounts to offense under section 13(1)(a) read with 13(2) of the PC Act 1988. This is very, very strange finding, Your Lordship. Resultantly, the accused Mr. So-and-so Western Circle is convicted under section 409 of IPC and under section 13(2) read with section 13(1)(a) of PC Act 1988. So, after recording all the evidence on whether the accused had taken illegal gratification of 3 lakhs from PW4, the trial court has come to the conclusion that I am guilty of 409 criminal breach of trust and criminal misconduct because I
For 3
violated-
lakhs, 17 lakhs has been set aside, isn't
Yes,
it?
so
So
the
this is
only question
basically for
we-
3 lakhs.
3 lakhs. So the charge is whether I took illegal gratification of 3 lakhs from PW number 4. The finding is that I had violated the PWD manual. That's why I'm guilty of breach of trust and criminal misconduct. But how can that be? Number one, there is no charges were never framed regarding PWD manual and its violation. That itself amounts to violation of the principles of natural justice. You frame a charge against me under a particular section of law in light of a certain position of facts, and then you go on to convict me on certain other on some other facts which was never pleaded by either the prosecution or anyone else. It was never the case of the prosecution that PWD manual was violated. In any event, even assuming but not admitting that that was part of the prosecution's pleading, the proviso to that clause 33.13 of the PW manual clearly states that a piece of work will not be regarded as subletting. Number one. Number two is that PW number 3 himself, the contractor himself, has stated that I subletted part of my contract to PWD number 4. Where does the appellant come into the picture?
Yes, that's what I was just going to ask you. Who sublets his contract?
It was the
It will be
PWD
the
number 3 who
contractor,
subletted
isn't it?
his contract to the PWD number 4. I am only a supervising JE. So that is the situation. Now, if I can take your lordship's attention to the sentence order, which is at page 117. Page 117 starts sentence order dated 5/9/2023 is there, and the first page is regarding the submissions of the respective counsels. And at page 119, para 7, before pronouncement of the sentence, this is the finding of the trial court. Page 119, para 7. Upon hearing the rival contentions of the learned counsels of the parties and on considerations of the milieu of offences, this court find following circumstances to inflict lesser term of punishment, namely, no previous criminal records, breadwinner in a family and also head of family. Number 3, no proof of corrupted money and pocketed by the convicted accused. This is the finding of the trial court. Rightly or wrongly, a trial court cannot have its finding unless it is based on the evidence. So the trial court itself has stated that there is no proof of corrupted money, and yet I'm being convicted.
Anyway, so
anyways,
where is he convicted? Under section for what? Let's come to that part
Yes,
then.
the next page, Your Lordship. Page 120, para 9. On evaluating as extenuating and aggravating circumstances, this courts find and deem it appropriate that the convicted accused person, namely Mr. So-and-so, is sentenced to the following prescribed minimum terms, namely, sentence under section 409 of IPC to undergo 2 years imprisonment with a fine of rupees 1 lakh, in default another imprisonment of rupees 6 months. Sentence under section 13(2) read with 13(1)A of PC Act 1988 to undergo 4 years imprisonment with a fine of 1 lakh, ID another imprisonment of 6 months. So 409 and section 13. So number one, Your Lordship, I would like to come to my grounds. So
Wait,
here,
let's go back to the framing of charge.
framing of charge, which is
Because-
at page 4. Page 4. Charge
Page
with 2
4.
heads.
So, when he convicts him under 409, 409 is for both receiving 17 lakhs and 3 lakhs. Okay, for these two offences, he was convicted under, he was charged under 407.
So 409, Your Lordship.
409, and on his conviction, 409, that means he must have been convicted for the offence of receiving maybe 3 lakhs.
3 lakhs.
Because 17 lakhs, nothing found. Okay. Then 13.2, again receiving the same amount of money in the, at the time of consideration of charge,
In fact,
committed criminal misconduct for receiving 17 lakhs. Since 17 lakhs was not received, it will be
3.
receiving the 3 lakhs criminal misconduct. Okay.
Criminal breach of trust and criminal misconduct. Conviction is under 409, criminal breach of trust.
But in the reasoning made, I'm just trying to figure out.
Right. So,
Page 119, no proof of corrupted money and pocketed by the convicted accused. Okay. But still convicted for pocketing 3 lakhs, most probably.
most probably.
Is it? Huh.
I mean,
okay.
that
I'm
would be
trying
my
to-
the only logical. But
I'm just trying to understand. Yes.
the findings, I would like to reiterate, is that it was for violation of PWD Manual 2014.
Okay.
Whether violation of rules and regulations of a department by a public servant warrants conviction under 409 and section 13 or not.
Okay,
That is
but
something I would like to.
okay, yes, under the PWD manual, is there provision, some sentence for violation? Is there something?
It's quite bulky. It's quite voluminous.
But
I haven't particularly gone through that, especially considering the fact that no charges were framed against
okay,
me.
but at the time of framing charge, that was not mentioned.
That was not mentioned.
Okay,
In
fine.
fact, as we have read out the entire evidence, there is not a single mention of PWD manual by any parties, including the prosecution and the special
Okay,
prosecution.
313, where is the 313?
313 is at page 6.
Anything there? Nothing.
We can go through my notes. Not much, actually. I mean, since we've read everything, might as well. Page 6, I'll just read. It is in the evidence that you were junior engineer in Public Works Department at the relevant time. What do you want to say? Yes, it is in evidence that as per Office Order Memo Number so-and-so dated 28 November 2017, your assignment of work was Kozol Subdivision and you remained there until you were transferred to Western Circle. What do you want to say? Yes, it is in evidence that when you were in PWD Kozol Division, you were assigned to supervise the work of maintenance of Rabung to Aiduzol Road. What do you want to say? Reply is yes. It is the evidence that you were posted at Kozol Subdivision. Mr. Lalro Eng, a Republic Bank, was allotted construction of Rabung Aiduzol Road, M02 so-and-so, and routine maintenance for 5 years after completion of construction under PMGSY. What do you want to say? Yes. It is in evidence against you that the said contractor Lalro Enga had sublet some construction of retaining wall Sri Van Ming Thanga, son of so-and-so, Kozol Vengter, as you asked him on behalf of Sri Van Ming Thama for obtaining subcontract works for the contractor. What do you want to say? Yes, being poor condition and where I was lodged in their residence at Kozol during my posting as Van Ming Thang applied subcontract work to the contractor, Mr. Lalro Enga, I also stated to the said contractor that I also wish if he can allot subcontract work to the said Mr. Van Ming Thanga. It is in evidence against you that being in charge of the construction of Rabung to Aiduzol Road, you demanded some money as bribe from the contractor, Mr. Lalro Enga. What do you want to say? I totally deny the said allegation against me. At that time, as our family was facing financial constraint, I asked some money for borrowing to Mr. Lalro Enga. He allowed and lent me rupees 17 lakhs. It is in evidence against you that Mr. Lalro Enga, being a contractor under your supervision, had transferred a sum of rupees 17 lakhs from his ICICI bank number so-and-so to your SBI account number so-and-so on 4/1/2020, as you illegally demanded and by abusing your official position as 7 JEPWD. Do you want to have any explanation? Transfer of the said money is corrected, but I did not demand to him. It is in the evidence against you that being in charge of construction of Rabung to Aiduzol Road as well as giving some help to Mr. Van Ming Thanga, you demanded some money as bribe from him. What do you want to say? I totally deny the above allegation against me. Prosecution evidence further reveals that you repaid as aforesaid rupees 17 lakhs to the contractor, Mr. Lalro Enga, after registration of the incident case in Mizoram Lokayukta and as you try to avoid the instant prosecution. Do you have any explanation? I admitted that I repaid the said rupees 13 lakhs to the contractor, Mr. Lal Roena, after registration of the instant case in Mizoram Lokayukta. Meanwhile, I deny that I repaid the same to avoid the instant prosecution. I would like to state that as and when I am able to repay the said borrowed money, I repaid to Mr. Lal Roena when I was in a position to repay. It is in evidence against you that Mr. Van Huing Thanga, being a subcontractor under your supervision, had transferred a sum of rupees 11 lakhs from his SBI account number so-and-so to your SBI account number so-and-so, as you illegally demanded and by abusing your official position as JEPWT. Do you want to have an explanation? It was not a bribe money and also not a matter of abusing my official position as JEPWT. The said Van Huing Thanga, when he pursued subcontract work and as he did not have such money to start the work, he borrowed rupees 88 lakhs from me for the first time. As the amount remained insufficient, he borrowed another rupees 3 lakhs from me. Mr. Van Huing Thanga thereby repaid the said borrowed money amounting to rupees 11 lakhs on date 19/11/2019 by bank cashless transfer. It is in evidence against you that by taking monies from the contractor and subcontractor, you committed criminal breach of trust as well as criminal misconduct. What do you want to say? I totally deny allegations against me, namely criminal breach of trust and criminal misconduct. As I already explained above, I therefore innocent in the instant case. Do you want to have an explanation on your case? I totally deny allegation against me. I would like to further clarify that for the contract work in the instant case, after thorough survey conducted by the concerned officials, DPR was prepared like in the instant PMGSY road on the basis of approved DPR. Contractual agreement was entered by the contractor. My function and duty as JE was to supervise the work as per DPR and their contractual agreement. I am therefore not in position to add or reduce estimates. As the contractor completes the work, being a JE, I prepared bills and was countersigned by the SDO concerned, subject to approval of the executive engineer concerned. PMGSY scheme is a very complicated and stringent. Being a JE, it is not possible to modify or nullify the project work. It was also supervised and monitored by state quality control and monitoring authority, even at national level. So, do you want to reduce evidence? And the reply was in the negative. So, those are the facts of the case, Your Lordship. So, basically, both the contractor and the subcontractor denies the allegation. They were declared as hostile. The PP, public prosecutor, was given ample opportunity of cross-examining the witnesses, and the conclusion appears to be that whatever money was given, they have been returned. No money has been pocketed by the accused. There was no enrichment. As such, in light of the findings and the conviction under section 409, I would like to place reliance on one judgment of the apex court just to discuss what are the ingredients necessary for conviction for 409, that is criminal breach of trust. This is 2021 SEC online, SC 1232, in the case of N. Raghavendra versus State of Andhra Pradesh. Again, this is also a PC Act case, Your Lordship.
2021, 18 SCC 70.
N. Raghavendra versus State of Andhra Pradesh. I would be placing reliance on section 41. Lordship has it?
Para?
Para 41, sorry.
Yes.
Ingredients necessary to prove a charge under section 409. Your Lordship has it? I hope we're on the same page, Your Lordship.
Para 41, isn't it?
Yes.
Yes. We may point out.
Yes, I'll just read from para 41 onwards.
Yes.
Section 409 IPC pertains to criminal breach of trust by a public servant or a banker in respect of the property entrusted to him. The onus is on the prosecution to prove that the accused, a public servant or a banker, was entrusted with the property which
I don't think we are on the same para.
This is N. Raghavendra versus State of Andhra Pradesh, CBI.
So,
I'd given the
para,
citation memo.
citation is there. Now the para, just come back to para 41. Okay. Just
heading
scroll up on top. It'll be para, go up. Keep going up. I think it's 37, 38.
The heading will be ingredients of.
Yes, just go ahead. I saw it somewhere. Maybe the
says-
paragraph is different.
Ingredients necessary to prove a charge under section 105. It's written, it's underlined and bold.
Okay, go down, go down. It will be good if you have another screen here for the lawyers to see also, then it will be more easy. This is analysis, okay?
There's after analysis, after a few paragraphs
So just keep going
After-
up.
analysis, there will be ingredients necessary to prove.
Okay, scroll down. And para 42, come to para 42, 43. Yes, so here it is in para 44.
Oh, I apologize. I'd given the citation memo.
Oh, para 44. This is from the SCC online. SCC, huh? Yes.
So we have this, the heading is ingredients necessary to prove a charge under section 409 IPC. It reads as follows. Section
Yes.
409 IPC pertains to
Para
criminal
45.
breach of trust. Are we on the same page, Your Lordship?
It's para 45.
All right.
Yes.
409 IPC pertains to criminal breach of trust by a public servant or a banker in respect of the property entrusted to him. The onus is on the prosecution to prove that the accused, a public servant or a banker, was entrusted with the property which he is duly bound to account for and that he has committed criminal breach of trust. The entrustment of public property and dishonest misappropriation or use thereof in the manner illustrated under section 405 are sine qua non for making an offense punishable under section 409 IPC. The expression criminal breach of trust is defined under section 405 IPC, which provides inter alia that whoever being in any manner entrusted with property or with any dominion over a property dishonestly misappropriates or converts to his own use that property or dishonestly uses or disposes of that property contrary to law or in violation of any law prescribing the mode in which such trust is to be discharged or contravenes any legal contract, express or implied, etc., shall be held to have committed criminal breach of trust. Hence, to attract section 405 IPC, the following ingredients must be satisfied. Entrusting any person with property or with any dominion over property. That person has dishonestly misappropriated or converted that property to his own use. Or that person dishonestly using or disposing of that property or willfully suffering any other person so to do in violation of any direction of law or legal contract. It ought to be noted that the crucial word used in section 405 IPC is dishonestly, and therefore it presupposes the existence of mens rea. In other words, mere retention of property entrusted to a person without any misappropriation cannot fall within the ambit of criminal breach of trust. I would like to emphasize on this particular sentence. Mere retention of property entrusted to a person without misappropriation cannot fall within the ambit of criminal breach of trust unless there is some actual use by the accused in violation of law or contract coupled with dishonest intention. There is no criminal breach of trust. The second significant expression is misappropriates, which means improperly setting apart for one's use and to the exclusion of the owner. No sooner are the two fundamental ingredients of criminal breach of trust within the meaning of section 405 IPC proved, and if such criminal breach is caused by a public servant or a banker, merchant or agent, the said offense of criminal breach of trust is punishable under section 409 IPC, for which it is essential to prove that the accused must be a public servant or a banker, merchant or agent. She must have been entrusted in such capacity with property, and she must have committed breach of trust in respect of such property. Accordingly, unless it is proved that the accused, a public servant or a banker, etc., was entrusted with the property which is duty bound to account for, and that such a person has committed criminal breach of trust, section 409 IPC may not be attracted. Entrustment of property is a wide and generic expression. While the initial onus lies on the prosecution to show that the property in question was entrusted to the accused, it is not necessary to prove further the actual mode of entrustment of the property or misappropriation thereof. Where the entrustment is admitted by the accused or has been established by prosecution, the burden then shifts to the accused to prove that the obligation vis-à-vis the entrusted property was carried out in a legally and contractually acceptable manner. So, in the present case, the prosecution has failed to prove mens rea. Number two, where is the question of misappropriation? There is no misappropriation at all, the second criteria. And moreover, what we have just read out, the property which is entrusted to the person would relate to
Yes.
public property. Whatever the arrangement what was made between the PWD number 4 and the accused was in their private capacity. It has nothing to do with public money. And there is no question of misappropriation because the PWD number 4 himself has stated that I had taken this much money from the accused, and as such, I'm simply returning it. So where is the loss? There is no loss. So there cannot be a question of attracting the provisions of section 409 in the instant case. As such, the accused could not have been convicted under section 409 for criminal breach of trust. Now, the second conviction was under section 13 of the Prevention of Corruption Act. That is criminal misconduct by a public servant. In this respect, I would like to rely on another judgment, 2017, volume 14 SCC 442. 2017, volume 14 SCC 442. Para 20. In para 19, they have reproduced the section 13(1)(e) of the old act, but it speaks about the same one and the same subject: criminal misconduct by public servant. Para 20 onwards. May I read, Your Lordship? As ordained by the above statutory text, a public servant charged of criminal misconduct thereunder has to be proved by the prosecution to be in possession of pecuniary resources or property disproportionate to his known source of income at any time during the period of his office. Such possession of pecuniary resources or property disproportionate to his known source of income may be his or of anyone on his behalf, as the case may be. Further, he would be held to be guilty of such offense of criminal misconduct if he cannot satisfactorily account for such disproportionate pecuniary resources or property. The explanation to section 13(1)(e) elucidates the words known sources of income to mean income received from any lawful source, and that such receipt has been intimated in accordance with the provisions of law, rules, orders for the time being applicable to a public servant. From the design and purport of clause E of section 1 to section 13, it is apparent that the primary burden to bring home the charge of criminal misconduct thereunder would indubitably be on the prosecution to establish beyond reasonable doubt that the public servant, either himself or through anyone else, had at any time during the period of his office been in possession of a pecuniary resources or property disproportionate to his known source of income. It is only on the discharge of such burden by the prosecution, if he fails to satisfactorily account for the same, he would be in law held guilty of such offense. In other words, in case the prosecution fails to prove that the public servant, either by himself or through anyone else, had any time during the period of his office been in possession of pecuniary resources or property disproportionate to his known source of income, he would not be required in law to offer any explanation to satisfactorily account therefor. A public servant facing such charge cannot be comprehended to furnish any explanation in the absence of the proof of the allegation of being in possession by himself or through someone else of pecuniary resources or property disproportionate to his known source of income. As has been held by this court, amongst others, in state of Maharashtra versus Dhyaneshwar Lakshman so-and-so, even in a case when the burden is on the accused, the prosecution must prove the foundational facts. Incidentally, this decision was rendered in a case involving a charge under section so-and-so, so-and-so. So, in the present case, there is no evidence to show that I was in possession of certain property or pecuniary resources which was beyond my known source of income. And here, Your Lordship, I would like to, my conviction, as per the judgment and order, was under section 13(1)(a).
Okay, 13(1)(a). Is it?
I apologize. Under section 13(2), read with 1A. 13(2) is basically the punishment. 13(1)(a).
13.
1A of the amended act.
Okay.
Page 110 of the judgment of the paper book is the judgment and order.
I'm still looking at the framing of charge where it's, anyways, 13(1)(a). Page?
Page 110. So it says convicted under section 409. 409 we have already covered. And under section 13(2), 13(2) is basically the punishment. Read with 13(1)(a). 13(1)(a).
So let's come to 13(1)(a).
Yes, Your Lordship. Section 13, criminal misconduct by public servant. A public servant is said to commit the offense of criminal misconduct if he dishonestly or fraudulently misappropriates or otherwise converts for his own use any property entrusted to him or any property under his control as a public servant or allows any other person so to do. So dishonestly, there has to be if he has misappropriated it or if he converts it for his own use, any property that was entrusted to him or under his control or allows any person to use such property. So if we break down this 13(1)(a), into three parts. Dishonestly or fraudulently misappropriated, or it is converted for his own use, any property entrusted to him, or number 2, number 3, any property under his control as a public servant or allows any person to use such property.
So you're saying that supposing this was a case, would it have been more appropriate if he was convicted under B? Enriches himself.
In my humble opinion, it would not be appropriate to convict the appellant at all, considering the facts and circumstances of the case. Because, number 1, there is no misappropriation. All the money is accounted for. There was no property that was converted by the appellant for his own use, because the learned trial court himself has held that there is no what was the word? Money pocketed, I think. I think the particular sentence was that no proof of corrupted money and pocketed by
Anyway, it's time for this thing break. We
Yes,
can
sir.
continue. See, at the time of framing charge, the nature of the offense which he is alleged to have been committed, we'll make it alleged
Right.
to have been committed. I'm just thinking, won't it be more appropriate if he was then convicted or charged under B? Intentionally enriches himself, whether he returned the money or not, we're not going into that issue, but the charge.
there was
From
a-
the nature of the allegation made against him, just for discussion,
yes.
won't B have been more appropriate? I'm just saying. Anyways, we'll continue. at 2.
Yes, Your Lordship.
Yes. We were at
Yes,
section 33. No, 13. Yes, 13(1)(a), isn't it?
Right. So I was trying to impress upon your lordship, given the facts of the case and by placing reliance on those two Supreme Court judgments, our humble submission is that the ingredients necessary to satisfy for attracting the provisions of 409 and section 13 are entirely missing in the instant case. As such, the judgment and order is liable to be interfered with and set aside. And secondly, your lordship, and moving on from those submissions, I just have only two more submissions, your lordship. Number one is that if we go through the judgment and order, the actual findings of the trial court for convicting the present appellant was with regards to that violation of that PWD manual. Now, in addition to that, the learned trial court has also made a finding. I am referring to page 110, paragraph 43. The finding part of that point number 3. Paragraph 43, page 110,
43, yes.
110. So I've already read it. The last.
Yes.
I'm just reading at paragraph 42, 3, the 8th line from the bottom. So this has also reveals that profit of the said subcontract work, if at 10 lakhs, which is very exorbitant rates, amounts to detrimental to public interest. I think the learned trial court is slightly has failed to fully appreciate the fact that 10 lakhs in itself does not mean that these are the profits of the contract work. It's not necessary that this 10 lakhs is the contract work. And secondly, all the assessment has been made by the PWD by relying on and calculated and paid by the PWD through the to the PW number 4 by relying on the standard operating rates of the government. Now, when the concerned authority has not raised any question regarding this, and secondly, when there is nothing in evidence to show that this 10 lakhs is in fact the actual profit, how did the trial court come to this conclusion? This is a baseless conclusion. And so far as the subletting is concerned, Your Lordship, number one is that I've already submitted that since in this particular case, since the PW number 4 was working only on a piece of work amongst the different nature of work involved in the contract, the question of attracting the PWD manual clause 33.13 could not have arisen, because the proviso to that same clause would come into play. Assuming but not admitting that this is the case, whether the same would warrant a conviction under section 409 or not, or whether the same would warrant a conviction under section 13, that has to be examined also. In any event, there is not a single evidence led by the prosecution during the entire proceedings, even the investigating officer, regarding violation of the so-called PWD manual, which was not even exhibited. No charges were framed with regards to the subject matter which I'm referring to right now, in spite of the fact that this trial court had all the powers under section 216 to alter the charges anytime before the pronouncement of the judgment. These were not done. Despite the lack of alteration of the charges, the appellant was convicted on an allegation which was never made by the case IO or the prosecution. Thereby, there is a clear violation of the principle of natural justice, because I was denied any opportunity to lead evidence on this particular point. And remaining
Yes,
on
go
this
ahead.
point, yes, I would like to place reliance, a very recent judgment of the High Court of Kerala, which is quite similar to the present case. This is also a prevention of corruption case. In this particular case, Your Lordship, the petitioner was also held guilty of certain provisions of the Act because he had failed to act as per the tender manual while awarding the tender. So I've already given it to the citation memo is there. 2024 SEC Online, Kerala 210. C. Surendranath versus State of Kerala. I am referring to para 27. May I read, Your Lordship?
Yes, go ahead.
So, dishonest intention is sine qua non to attract the offense punishable under section 13(1)(d) of the Act. Mere conduct and action of the accused, contrary to the rules and departmental norms, would not amount to criminal misconduct by a public servant. A fundamental principle of criminal jurisprudence with regards to the liability of an accused is the element of mens rea. On the principles of actus reus and mens rea, the learned author, so-and-so, comments us, the mere commission of a criminal act or bringing about the state of affairs that the law provides against is not enough to constitute a crime, at any rate in the case of the more serious crimes. These generally require, in addition, some element of wrongful intent or other fault. Increasing insistence upon this fault element was the mark of advancing civilization. On the principles of criminal liability, the learned author Sri K.D. Gore, in his books Criminal Law, explains thus: criminal guilt would attach to a man for violations of criminal law. However, the rule is not absolute and is subject to limitations indicated in the Latin maxim actus non facit reum nisi mens sit rea. It signifies that there can be no crime without a guilty mind. To make a person criminally accountable, it must be proved that an act which is forbidden by law has been caused by his conduct, and that the conduct was accompanied by a legally blameworthy attitude of mind. Thus, there are two components of every crime, a physical element and a mental element, usually called actus reus and mens rea respectively. Dishonest intention is the crux of the offense under section 13(1)(d) of the PC Act. The question of whether violation of the rules and departmental norms would amount to the offense under section 13(1)(d) of the PC Act was considered by the Apex Court in C.K. Jaffer Sharif versus State. If in the process the rules or norms applicable were violated or the decision taken shows an extravagant display of redundance, it is the conduct and action of the appellant which may have been improper or contrary to departmental norms. But to say that the same was actuated by a dishonest intention to obtain an undue pecuniary advantage will not be correct. That dishonest intention is the gist of the offense under section 13(1)(d) is implicit in the words used, that is, corrupt or illegal means and abuse of position as a public servant. In M. Narayan Nambiar versus State of Kerala, while dealing with section 5 of 1947 Act, the Apex Court held that dishonest intention is the gist of the offense. In the present case, the prosecution records reveal only a violation of the rules and the departmental norms or procedural norms for the tender process. The prosecution failed to produce any material to show that the petitioners with dishonest intention committed any acts. It is also important to note that there is absolutely no allegation in the prosecution case that the petitioners obtained any pecuniary advantage. I'll just stop here because it goes on to the facts of the case. Similarly, in this case, Your Lordship, there is no misappropriation of money. There is no illegal enrichment. No public money has been misappropriated. The prosecution has failed to show any of these things. The prosecution has failed to let any evidence to satisfy the ingredients necessary for conviction or which warrants a conviction under section 409 or section 13 of the PC Act. And so far as the so-called subletting issue is concerned, Your Lordship, it is a PWD manual, number one. I'll just leave out the fact that no charges were framed or no evidence was led on this point. But the fact of the matter is it's a PWD manual. It's not a statutory act. Whether the violation of such manual will warrant a conviction under IPC, whether it warrants a conviction under the PC Act, it may warrant a departmental inquiry, no doubt, but not under IPC or PC Act. And that is what the Kerala High Court has also cemented while coming to its conclusion in the case record, case which I've just relied upon. So, in light of that, Your Lordship, my humble submission is that, and also the fact that the trial court itself has held that there is no corrupted money. Taking all these things into consideration, our humble submission is that the prosecution has miserably failed to prove their case beyond reasonable doubt, and that this is a fit case for this honorable court to exercise its appellate jurisdiction and dismiss the judgment and order and the sentence order as lacking merit and exonerate the present appellant from all charges, Your Lordship. With that, I complete my submission, and I would like to reserve my rights to reply to the submissions of the respondents.
Yeah, please, Your Lordship. As has already pointed out,
We just one question. Now, counsel for the appellant, you have on and off stated that the money was returned.
Madam.
Now, in the exhibits, the bank statement was also shown. Receiving the money and also returning, is it anything like that?
No, my lord. So far as that 3 lakhs is concerned, it was returned, it was given by cash and returned in cash. There was no bank statement as such. That is as per
Concerning the 17 lakhs, no.
No, we're not concerned with 17 lakhs because
Okay,
the case-
17 lakhs anymore, okay, fine,
That
because
was-
he was found
Yes,
not,
that
okay,
was not
fine.
proved.
So it is not reflected in the bank account because it was
monetary
given in cash.
transaction,
Okay,
cash.
fine.
That was as per the statement of the PWD number 4. And
Who was
the
declared a
appellant.
hostile witness.
Right.
Right.
but as I have already pointed out, the state has a very limited role in this case. First of all, we have a request was made to the chairman, Mizoram Lokayukta, to investigate embezzlement of government money on 20th May 2020. And after that, my lord, the Lokayukta has requested the ACB to investigate. So our role is only to investigate the matter. And
Where's that? Let's go back. Where did you request Lokayukta? Your involvement is
page 155, my lord, is the
at page 155.
request to
is it?
investigate embezzlement of government money. Page 155. This is written by the Deputy Secretary PWD to the chairman, Mizoram Lokayukta. And thereafter, my lord, we were handed over to investigate the case. And during investigation, my lord, we have conducted all the inquiries. We have taken the statement of the appellant himself, the contractor Lal Roenga, and subcontractor Van Minh Thanga. And we have, on the basis of their statement, we have taken out the statement of account, their accounts, wherein we have found that there was some monetary transaction between the appellant and the contractors. So on the basis of that, my lord, the ACB has submitted the charge sheet. Your lordship will see the charge sheet is at page 186. Page 186.
Yes.
At the top, my lord, it's written out here. Final form report under section 173 CRPC in the Court of Special Judge PC Act cases for Mizoram Lokayukta. So we have submitted this charge sheet on the basis of the complaint that was received by Mizoram Lokayukta. And your lordship is also aware that the Special Judge PC Act also acts as a special court of Mizoram Lokayukta since June 2020. So on the basis of that, my lord, we have submitted this charge sheet. And in the light of the investigation, my lord, the charge sheet starts from 192. During the investigation of the case, we have recorded the statement of the complainant, the appellant, and the contractor, Mr. Lel Roenga, and the subcontractor, Van Ming Thanga. And we have also seized the detailed statement account of Lel Roenga, the contractor, and the detailed statement of Van Ming Thanga, the subcontractor.
So,
And at serial number 7, my lord, page 193, we have seized the account statement of SBI Mission Bank account number so-and-so belonging to Sigal Pakoma.
I think you should switch off the AC. Yes, 193.
193. At para 7, my lord. Seized the account statement of SBI Mission Bank account number so-and-so belonging to Silal Fakoma JE, in which rupees 17 lakhs and rupees 11 lakhs was credited on 4/1/2020 and 19/11/2019 by Roenga contractor and Van Ming Thanga subcontractor respectively. Van Ming Thanga Khozol, who is working under Lel Roenga as subcontractor, stated that he borrowed rupees 8 lakhs from Silal Fakuma, and he returned the money amounting to rupees 8 lakhs, and he added rupees 3 lakhs for gratification, totaling rupees 11 lakh, and credited to account number so-and-so belonging to Lel Fakuma, JEPWD. And at the next page, my lord, at page 194.
Yes.
Serial number 1, my lord, para number 1. Construction and maintenance of Rabung Aiduzol Road. Contractor Lel Roenga, Republic Bank Aizol. The investigation reveals that in this contract work, Silal Fakuma JEPWD asked the contractor Lel Roenga to give money. The contractor Lel Roenga gave him rupees 17 lakh only from his total bill, and he transferred rupees 17 lakh from his ICICI account number so-and-so to the account of Silal Fakuma JEPWD so-and-so on 4/1/2020, which can be seen from the above two detailed statement of account statement of Lel Roenga was recorded, in which he affirmed that he gave rupees 17 lakh to the accused Silal Fakuma JEPWD on 4/1/2020. And the next para, on 19 November 2020, Silal Fakuma JEPWD took another bribe money from subcontractor Van Ming Thanga, son of Zolian Pung of Khozol, Veng Thar, near Presbyterian Church. The said subcontractor was working under Lel Roenga contractor Van Ming Thanga, who stated that he borrowed money amounting to rupees 8 lakhs from Silal Fakuma JEPWD as working capital for construction of retaining wall in the Lel Roenga. However, he returned rupees 11 lakhs on 19/11/2019 from his account number so-and-so of SBI Khozol branch and transferred to Silal Fakuma JEPWD account number so-and-so. From the above fact and evidences, a prima facie case under section 409 IPC read with 13(1) AB and 13(2) of PC Act 1988 had been well established against Silal Fakuma, Junior Engineer PWD, so-and-so, Cutlass South, now posted at Western Circle, White so-and-so, for taking bribe from contractor Lel Roenga, Republic Bank, Aizol, and subcontractor Van Ming Thanga, Khozol, Veng Thar, amounting to rupees 17 lakhs and rupees 3 lakhs, respectively, totaling rupees 20 lakhs. Hence, prayer for prosecution sanction was submitted, and the Secretary to the Government of Mizoram PWD issued prosecution sanction order against Silal Fakuma, Junior Engineer PWD, Western Circle, White so-and-so. So, my lord, this is our investigation. Up till the investigation and filing of charge sheet, my lord, there was not a hint that the money was borrowed. We have taken the statement of the contractor and the subcontractor, and we have come to the conclusion that this was a corrupted money, and there was no hint from either the contractor or the subcontractor that it was borrowed. And later on, my lord, during trial, they have deviated from the statement. That is not within the knowledge of the investigating agency.
Okay.
That is my submission, my lord.
May I please, Your Lordship? I have 4 grounds for my submission.
Yes.
So I just want to brief up. First point is that this appeal is not maintainable in as much as the main parties is not array. As learned PP for the state submitted that we did not have any role to play except investigation, because the whole thing was taken up by Mizoram Lokayukta. That's number 1. Number 2, the hostile witnesses, the statement of the hostile witnesses cannot be accepted in view of the judgment on Supreme Court recently, recently Niras, recent judgment 2023 by 5 judges. And number 3 is the statement of the contractors and subcontractors claiming that the money given to the accused, the appellant, was borrowed money, was afterthought. And another ground is that he keep on barking that no money, no proof of corrupted money, and pick it by the convict person in the sentence order. He relied upon that statement many times. In counter to that, that statement is in respect to the point number 2 only, wherein the appellant was given a clean sheet, not in respect of point 3, not as a whole, not in entirely, but to some extent that there was, in respect of like 17 lakhs, the prosecution they failed to prove that there was a corrupt money, in respect only, not in respect of the third point. So, and another, my last point is that no prosecution sanction is not required in respect of the prosecution by Mizoram Lokayukta, as per section 22 of the Mizoram Lokayukta Act. Because the very purpose of this Lokayukta, Lokpal also, and Mizoram Lokayukta is that the very complicated getting prosecution sanction was removed. Because the very intention of the statutes of Lokayukta is speedy disposals of the case. Because it happened many times in respect of prosecution sanction, there are many issues which delay the trial also. Because of that, this act came into being. So on those 4 points, I'll rely my submission. So my point number 1 is that, Lordship, very short brief of this case is that very simple, very short, though there are many witnesses who abundantly, very clearly proved in respect of 17 lakhs, this is all admitted fact. And that the contractor, 7 lakhs was transferred to the account of the appellant on 4th January 2020.
17 lakhs,
yes,
isn't it?
yes. And also those statements were proved by all the witnesses. that those who come from the bank, those who I can witness number 8, 9, 7, and 10. They are reliable witnesses. This is one part. And the defense that it was borrowed money, they did not have any proof. And second point is that in respect of 3 lakhs, that it was transferred, that 21 lakh was transferred on 15/11/2019 to the account of subcontractor. Again, 11 lakhs was transferred to the account of the accused, of the appellant, on 19/11/2019. Those 2 transactions only now we are in the issue.
No, for the 3 lakhs, 21 lakhs was transferred on 15/11, isn't
Yes,
it?
yes.
Then 11 lakhs on
11 lakhs on 19/11.
21 lakhs on 15/11.
Yes.
2019.
Yes.
11 lakhs on 19/11.
After 4 days, yes.
11/20.
2019. After 4 days.
Okay.
So
Just
these
after
2
4 days,
transactions only. So now I'll not stretch much upon on 17 lakhs because the trial court already found that there was no such illegal transaction. So despite it is very clear that the witnesses, all the witnesses prove very clearly that they have seen the transaction, they have witnessed the seizures of the accounts of SBI account and HDFC account. But I'll come to 3 lakhs. So it is not denied at all that 21 lakhs was transferred to subcontractor. Again, 11 lakhs was transferred to the accounts of the accused, the appellant, on 19/11/2019. It is not at all denied. So even the witnesses, PW 9, 10, and also another witnesses also they prove. Though they did not deny, I will not stretch much upon that. But I would like to stress upon that how this money, that 3 lakhs, became a demand in illegal gratification. If you kindly see, Lordship, without printing, I had given the copy of anticipatory bail petition to court master. If you kindly display.
Anticipatory
Yes,
bail made by
Lordship.
the, okay.
By Sid Alpha Comma.
Oh.
So what I want to stress is that this is afterthought. This grounds of that I had borrowed money, he had borrowed money, I had given is afterthought. Only after charge sheet was submitted. So if you kindly see this anticipatory bail, which was filed on 18/4/2023. Not even a single utters is there that the amount, the misappropriated amounts or the alleged amount 17 lakhs or 3 lakhs was borrowed by him, by anyone. If you kindly see para number 1, 2 is the prosecution sanction, and para 3 is the
Anticipatory bail was made on application on
18/4/2023.
Oh.
18/4/2023. So thinking back, charge sheet was filed, and there was no evidence or no statement at all that this 17 lakhs and 3 lakhs was borrowed money. So after they filed charge sheet, because it is very clear from all the statement that they knew very well, they're friendly, they're friend, and they work together. Then after he received charge sheet copies and he read it, and also I'll come later that there is evidence also that he kept in touch with him at the times of summoning of the witness also, the one who turns hostile also. If you kindly go through it, not even a single statement about the borrowed money is submitted here. This is my point. This is very clear that even the Supreme Court judgment Niraj Kumar stated that even indirect evidence can be relied upon for convictions of person in corruption case. And more specifically, this judgment by 5 judges is that the one who turned hostile also can be convicted I'll come later on. So, Your Lordship, I want to go to the evidence of this PW number 3, the contractors and subcontractor. Again,
Page?
I don't have paper book. PW number 3. 33. So, Lordship, I'll go from para number
Page
7.
33, is it?
Yes,
You tell me the pages, page 33, PW3.
yes. This is Lal Rowenga, the one who had given 17 lakhs. So para number 7, I will not read. I'll not go through the before para 7. It's all admitted. And as spread, this is bold letter. As spread by landed special PP, PW3 is declared as hostile. They became hostile. The one who made complaint initially became hostile at the times of on this one on 14 June 2023.
That we know. So,
Yes.
so give me the judgments regarding reliability of hostile witnesses.
I'll go to the first judgment. It was rendered by two judges, 2019, volume 14, SCC 311.
Three one one. Okay. Yes.
So, Lordship,
Para?
no, I'll come straight to the conclusion here. The conclusion is 15 and 16.
Para 15, 16.
The learned senior counsels for the respondent submit, may I kindly read?
Yes, yes.
That the court must take into consideration the facts and circumstances brought on record and may draw inference to arrive at the conclusion whether demand and acceptance of illegal gratification has been proved or not. Insistence of direct proof or primary evidence for proving the demand may not be in consonance with the view taken by this court in numbers of judgments. Lalan Senior Counsel has drawn our attention to other cases to substantiate her contention that Suntaya Naran had not taken note of the consistent view taken by the Supreme Court. We are not delving into the controversy any further. Para 16, we are of the opinion that the following issues requires consideration by the larger bench. The question whether in the absence of evidence of complainant, direct or primary evidence of demand of illegal gratification, is it not permissible to draw inference deductions of culpable or guilt of a public servant under Section 7 and Section 13, 1D read with 13.2 of the Prevention of Corruption Act 1988 based on other evidence adduced by the prosecution. 17. In light of the consistent view taken by this court in various judgments, we have some reservation in respect of the observation and findings recorded by this court in P. Santaya Naran Murthy versus State of AP. The matter be placed before the Honorable Chief Justice for appropriate orders. So, two judges referred to larger bench to decide whether.
Yes. So what is the judgment of the larger bench?
I had given it 2023, very recent.
Okay, this is the one.
Yes. 2023, volume 4, SCC 731. In fact, Your Lordship, it is appropriate to mention here that when this judgment came at the evening in the bench and bar life law, what it was reported in the heading is that testimony of hostile witnesses can be considered to convict accused. This is what in all the news, legal news and all come up. So I would like to.
Para?
My lord, before I go to the relevant para, I would like to take you to this one, the very introduction. It's at page number 746. 746. It was concurring finding by 5 judges. Here, the very first line, the introduction is, by order dated 27/8/2019, a 3 judges bench of this court had referred the questions of law framed to be decided by a bench of appropriate bench. That is how the batch of cases has been referred to Constitution Bench comprising of 5 judges by the Honorable Chief Justice of India. For an easy reference, order of reference dated 27/8/2019 is extracted under. I don't need to repeat again. This is exactly the same, the conclusions of the 2019 judgment. So the conclusion part is that from 87, para 87. Page number 775. You're there, Lawson? Therefore, this court cautions that even if a witness is treated as hostile and is cross-examined, his evidence cannot be written off altogether, but must be considered with due care and circumspection. And that part of the testimony which is creditworthy must be considered and acted upon. It is for the judge, as a matter of prudence, to consider the extent of evidence which is creditworthy for the purpose of proof of case. In other words, the fact that a witness has been declared hostile does not result in automatic rejection of his evidence. This is what I want to stress. Hostile does not result in automatic rejection of his evidence. Even the evidence of a hostile witness, if it finds corroboration from the facts of the case, may be taken into account while judging the guilt of the accused. Thus, there is no legal bar to raise a conviction upon a hostile witness testimony if corroborated by other reliable witness. Evidence 88. What emerged from the aforesaid discussion is summarized as under. Proof of demand and acceptance of illegal gratification by a public servant as a fact in issue by the prosecution is assigned qua non in order to establish the guilt of the accused public servants under Section 7, Section 13, 1D12 of the PC Act 88-2. In order to bring home the guilt of the accused, the prosecution has to first prove the demand of illegal gratifications and subsequent acceptance as a matter of fact. These facts in issue can be proved either by direct evidence, which can be in fact natures of oral evidence or documentary evidence. Further, in fact in issue, namely the proof of demand and acceptance of illegal gratification, can only be proved by such circumstantial evidence in the absence of direct oral and documentary evidence. In order to prove the fact in issue, namely the demand and acceptance of illegal gratification by the public servant, the following aspects have to be borne in mind. If there is an offer to pay by the bribe giver without there being any demand from the public servants, the latter simply accept the offer and receive the illegal gratification. It is a case of acceptance as per Section 7 of the Act. In such a case, there is no need to a prior demand on the public servant. This is very clear in our favor. He accepted it. On the other hand, if the public servant makes a demand and the bribe giver accepts the demand and tenders the demanded gratification, which in turn is received by the public servant, it is a case of obtainment. In case of obtainment, the prior demand for illegal gratification emanates from the public servant. This is an offense under Section 13, 1D1 and 2 of the Act.
Give me the PC Act. Go ahead.
In both cases 1 and 2 above, offer by the bribe giver and the demand by the public servant respectively have to be proved by the prosecution as a fact in issue. In other words, mere acceptance or receipt of illegal gratification without anything more would not make it an offense under Section 7 or Section 13, 1D1 and 2 respectively of the Act. Therefore, under Section 7 of the Act, in order to bring home the offense, there must be an offer which emanates from the bribe giver, which is accepted by the public servants, which would make it an offense. Similarly, a prior demand by the public servants when accepted by the bribe giver and in turn there is a payment made which is received by the public servant would be an offense of obtainment under section 13(1)(d) 1 and 2 of the Act. 85. Presumption of fact which regard to the demand and acceptance or obtainment of illegal gratification may be made by the court of law by way of an inference only when the foundational facts have been proved by relevant oral and documentary evidence and not in the absence of thereof. On the basis of the materials on record, the court has the discretion to raise a presumption of facts while considering whether the facts of demand has been proved by the prosecutions or not. Of course, the presumption of fact is subject to rebuttal by the accused and in absence of rebuttal, presumption stands. 88.
Go ahead.
In the events of complainant turns hostile or has died, is unavailable to let in the evidence during trial, demand of illegal gratification can be proved by letting in the evidence of any other witnesses, who can again let in evidence either orally or documentary evidence, or the prosecution can prove the case by circumstantial evidence. The trial does not abate nor does it result in order of acquittal of the accused public servant.
Yes.
My lord, these 2 points which I have highlighted in this judgment is that in case he accepted money from the bribe giver, this is square feet in our case. And also the proof does not require beyond reasonable doubt, circumstantial evidence, and if other factors is there, that is what it is.
So you're
highlighted.
saying that it is clear that he has accepted money.
Yes.
Money was there in his
Yes,
bank
there
account. I
are
think that's your
other
main point,
witnesses,
huh?
all bank officers,
Yes.
and also documentary evidence also there. Insofar as Section 7 is concerned, on the proof of fact in issue, Section 20 mandates the court to raise a presumption that illegal gratification was for the purpose of motive or reward, as mentioned in that section. The said, because
88.7, huh?
that 17 lakhs and 3 lakhs, it can be considered as reward also from the work itself, because it is so unprudent for the JE supervisor to lend money or to give money to the subcontractors or contractor. The prosecution can prove the case by circumstantial evidence. The trial does not, this one I have read, 88.7, my lord there. Insofar as Section 7 of the Act is concerned, on the proof of the fact in issue, Section 20 mandates the court to raise a presumption that illegal gratification was for the purpose of a motive or reward is there, as mentioned in the said section. The said presumption has to be raised by the court as a legal presumption or presumptions of law. Of course, the said presumption is also subject to rebuttal. Section 20 does not apply to Section 913 D12. In this case, kindly, Lordship, I would like to inform the court that the appellant herein does not have any witness. Even he himself did not stood as a witness also.
No evidence.
No evidence at all. He did not have. He just rely upon the hostile witnesses of the contractor and subcontractor. We clarify that presumption in law under Section 20 of the Act is distinct from presumptions of fact referred to above in sub-para 88.a above, as the former is mandatory presumption. The later is discussion in nature, 89. In view of the aforesaid discussion and conclusion, we find that there is no conflict in the three judge bench decisions of this court in Jayaras versus Satyanaram Murthy with the three judges bench decision in M. Narsingh Rao with regard to the nature and quality of the proof necessary to sustain a conviction of the offense under Section 7 and 13, such and such. I think my learned friend has referred this Narsingh Rao also. When the direct evidence of the complainant or primary evidence of the complainant is unavailable owing to his death or any other reason, the positions of law when a complainant or prosecution witness turns hostile is also discussed, and the observation made above would accordingly apply in light of Section 154 of the Evidence Act. Section 154 is that hostile witnesses, though any witness who called upon turns hostile, he can be cross-examined and his evidence can be
So they have
considered.
been cross-examined.
Yes,
in this
in view
case.
of the aforesaid discussion, we hold that there is no conflict between the judgment in aforesaid three cases. Accordingly, this is very important, the question raised for consideration of this court bench is answers as under. in absence of evidence of the complainant, direct, primary, oral documentary evidence, it is permissible to draw an inference deductions of culpability, guilt of a public servant under Section 7 and Section 13 and Section 13(2) of the Act on other evidence adduced by the prosecution. We direct that individual case may be considered before the appropriate bench after seeking orders of Honorable Chief Justice of India. Before we conclude, we hope and trust that the complainant as well as the prosecution make sincere effort to ensure that corrupt public servants are brought to book and convicted so that administrations and governance become unpolluted and free from corruption. In this regard, we would like to reiterate what has been stated in the corruption is rotting like cancerous lymph nodes and vital veins of the body politics, social fabrics of inefficiency in the public service, demoralizing the honest officers. The efficiency in public service would improve only when the corrupt servant devotes his sincere attentions and does the duty diligently, truthfully, honestly, and devote himself assiduously to the performance of duty of his post. Reputation of being corrupt would gather thick and unchaseable clouds around the conduct of the police officer, gain notoriety much faster than the smoke. This observation has been reiterated in A.B. Rao versus CBI, quoting under as below. It is difficult to accept the prayer of the respondent that a lenient view be taken in this case. The corruption by the public servant has become a gigantic problem. It has spread everywhere. No facets of public activity has been left unaffected by the stings of corruption. It has deep and pervasive impact on the functioning of the entire country. Large-scale corruption retards the nation-building activities, and everyone has to suffer on that count. We place on record appreciation. This is that. So the finding and the finding of these 5 judges' bench is that in case of corruption, indirect evidence can be relied upon, and also hostile witnesses, the evidence of hostile witnesses, also it can be relied and to convict the public servant. And also the proof required is not like beyond reasonable doubt. It can be from circumstantial evidence if there is another witnesses. So in my case, the long and short of my case is that regarding the grounds of borrowed money, it is only afterthought, as my learned friends PP for the state submitted that during the entire investigation, there is no such statement. If there is such borrowing at least 17 lakhs money, they should execute a deed. Or at least they'll write in a paper, or there will be at least documents to prove that transaction that 17 lakhs was paid to the appellant. And from the evidence itself, can I kindly go again to that part? 33 of the paper book. I'll read from 34. So since the contractors turned hostile, and special PP had to cross-examine, and from 8, you're there, Lordship?
Yes.
It is a fact that we put in a written form for lending and borrowing 17 lakhs between myself and the accused, because there is no record at all. It is a fact that on date 4/1/2020, I transferred 17 lakhs into the State Bank of account of the accused from my bank account, ICICI Bongkon. It was for the day of executing agreement in between myself and the accused for lending and borrowing 17 lakhs. So this is admitted fact. 17 lakhs was transferred from his bank account to the bank account, SBI bank account of the appellant. It is also admitted fact. So even if there is any written agreement, because there is a provision during trial also, if we want any documents to be exhibited or we want to rely, we can make application. So then that documents can be exhibited also. There is no such documents exhibited during trial in their favor. 10. It is a fact that we did not have any witnesses for executing agreement in between myself and the accused for lending and borrowing 17 lakhs.
You see, but he has not been convicted for the 17 lakhs.
Still,
the trial court only mentions, because the trial court did not find anything regarding the 17 lakhs. So we'll leave the 17 lakhs aside. he has been convicted for misappropriation of
3 lakhs.
I think 3 lakhs. So let's see PW
Yeah, because the reason why I highlighted is that because the story is same,
Oh.
their defense is same, but at least even the trial court also ought to have convicted under section
but
point number
nothing.
2.
So that there's an appeal against that. So let's look at the evidence of
Yes.
PW number 4. I
Lordship.
think that's more important in your
Yes,
case.
Lordship, in this respect.
From page
From
37.
37, all the statements are admitted fact. He's a subcontractor and he had transferred 21 and the 11 rupees lakhs was transferred to the accounts of the accused. I just want to, but again, read again para 5. Under Pu F. Lalroeng, a subcontractor work which I undertook was constructions of 3 retaining walls. The bill amounting 21 lakhs was transferred in my account by Lalroenga on 15/11/2019. After this, I worked as material supply record for about 1 month. I earned around 30,000 for this particular work because he himself admitted that 21 lakhs was transferred on 15/11. When the accused Sila Fakoma was posted here at Kozol, he befriended me and we became close friends. I was able to carry out the construction of 3 retaining walls because the accused had also requested Pu.F. Lalroenga to give the work to me in order to carry out the construction work. I was not having the capital, so I borrow the accused money amounting rupees 8 lakhs for completions of the work. On 15/11/2019, contractor Lalroenga transferred 21 lakhs in my account for completion of the work. Therefore, I transferred 11 lakhs to the accused Lal Fakoma account from my account number such and such on 19/11/2019. In this connection, in addition to 8 lakhs which I borrow from the accused, I later borrowed 3 lakhs from the accused as my construction work was expensive than I expected. So he admitted that. He also admitted that 11 lakh was transferred. Again, 3 lakhs was given to the accused. This is the thing. But here what comes surprising thing is that, new thing is that, which I borrowed from the accused. Which I borrowed from the accused. This is the first time it came that I borrowed. In fact,
That's
even
because
this
of,
8 lakhs.
Because of that, he was made hostile, isn't
Yes,
it?
even 8 lakhs was borrowed. 8 lakhs, that regarding borrowing of this 8 lakhs, it was admitted. During investigation also, it is the record that 8 lakhs was borrowed. But he never mentioned about this 3 lakhs was borrowed. In fact, if we read whether the court will accept it or not, and if we read very clearly that he demanded, their statement is that he demanded 17 lakhs. He demanded money. Even if we don't pay his or work supervisor, we cannot get the bill, the next bill. This is their statement. If your lordship, it is not a part of the, I don't have the paper book and it is a part of the record. That is what I want to mention. But the admissibility of statement before the police is crucial. I'll not go further. But here,
that was not questioned during cross, isn't it? In the
Yeah,
cross
but here-
examination, did they cross on that statement?
yes, definitely. I'll go down, lordship.
Come, read that.
So cross-examination, my landed special PP. In this point, Your Lordship, here, Mr. Jesiel Dunsanga. So what I want to make it clear that landed counsel for the appellant submitted that they merely assisted BP of the state. It is not that.
Anyways,
We,
go ahead.
we conducted the whole trial. I don't know why in this appeal they are afraid, or I don't know why they did not intentionally or unintentionally Mizoram Lokayukta. It's quite unfair. It is a fact that there was no written deed for borrowing 3 lakhs from the accused apart from the previous borrowed amount of 8 lakhs. It is a fact that I do not know the date of borrowing 3 lakhs from the accused apart from the previous borrowing of 8 lakhs. It is a fact that during beginning of 2019, I borrowed 8 lakhs from the accused. It is a fact that for borrowing 3 lakhs from the accused, I was handed over in cash by the accused in his residential house at Kozol. However, no other persons were available at the times of the said transaction. It is a fact that the accused did not insist me to repay 8 lakhs by means which I borrowed from him. It is also a fact that the accused did not insist me to repay 3 lakhs by any means which I borrowed from him. It is a fact that the police interrogated me in inspection bungalow at Kozol. I know the name of the police officer who interrogated me was Mr. Jerry. It is a fact that I also informed to the police officer who interrogated me about borrowing of 3 lakhs from the accused apart from the previous borrowing of rupees 8 lakhs. It is a fact that I did not ask the investigating team to make...
So you made a suggestion that he had informed about
Yes.
the 3 lakhs,
Yes.
which he admitted.
Yes.
So he says that it is a fact that I'm informed. Okay.
But
so
that-
when you questioned, you are making a statement which he confirms.
Yeah, he kept confronting, repeating it at the times of examination in chief also.
So he confirmed, and
But
you
the
also, you
police-
also are admitting that
Yeah, the
he had
cross-examination
borrowed
also he stood firm. Because that's
and
why...
your cross-examination also you are suggesting
Yes.
that he had later borrowed 3 lakhs, which he says it is
Yes,
correct.
that's why Supreme Court judgment came into play. Hostile witnesses, the evidence of hostile witness cannot
But
be relied
isn't
upon.
this your cross-examination? In your cross-examination, this is the cross-examination done by you, okay?
Because-
So in your cross-examination, you are making a suggestion that he had in fact borrowed the 3 lakhs.
Yes.
And which he says, yes, it is correct, I borrowed
Yes.
the 3 lakhs.
Yes.
So what type of anyways,
No,
so
Lordship,
you're admitting this point.
yes, he admitted at the times of cross-examination, even in chief also, but without asking that we cannot wholly admit the examination in part. So,
So you're
again,
not exactly crossing him on this point, you are confirming the point.
yes, exactly, because he denied. If he
fine.
said the truth, and the story will be different. But he lied in the court, that's why. His
okay.
evidence cannot be relied upon. So even to the police, because even Jerry also, even in the case in that one, the statement also, if it was recorded wrongly, the second point, I did not ask the investor to make...
Your cross-examination has been recorded correctly?
Yes,
Okay.
it is a fact that I did not ask the investigator to make any correction, change in my statement. So because he got it, he knew the statement, it was recorded. Because when charge sheet was filed also, he already knew. I'll read that one. He contacted also, the accused contacted also. It is a fact that, because the ninth point is that I did not ask the investigating team to make correction, change in my statement. 10 is that it is a fact that being a close friend, even after receiving summons to witness, I was also contacted by the accused. They kept in touch after summoning to the witness. It is a fact that accused also informed me that my statement recorded by the police was like bribe, corrupted money of rupees lakhs. Not mentioned that it was a borrowed money. It is very clear from the statement recorded by the police, SCB. It is a fact that I also asked the accused the date of borrowing rupees 3 lakhs from him, but were not ascertained. It is a fact that I do not know the money which I repaid to the accused was before or after registration of a case in Lokayukta. What is very unbelievable thing is that case was registered before Lokayukta first. Investigation took place. It was a long gap during this period. That time, even the accused himself could have made submission to the case IO, even at the time of filing anticipatory bail also, that it was not a corrupted money. I did not misappropriate. He should have stated that. Even we just have read that his anticipatory bail also. They kept quiet. They kept quiet all through these years. Since 2000, the case was first 2019, and first it was lodged before Lokayukta on...
You're saying that they kept quiet.
Yeah, they kept quiet.
They kept quiet, but at point 8, you mentioned that they had interrogated, and I mentioned
Because, Your Lordship, here,
page 39.
20th May 2020, complaint was lodged on 20th May 2020.
Anyways, sir.
See, May 2020, before that, there was departmental internal investigation on 20th May 2020. Before that, there was internal investigation also, wherein the imputation of the appellant was there. There is a record also. Even in that, it is there in I think 160. When the complainant to Lokayukta was on 155, page number 155. You're there? So before that also, here the complaint was enclosed along with this one. That's this statement, 156. May I kindly read? Very short.
Okay, the
156.
English version is in 158.
Yes,
You can read
156.
that.
Yes.
Oh.
May I kindly?
Yes, go ahead.
Khozol division hoya Khozol subdivision hoya heng PMGS way nate hi encol I encol 3 na
Page 158.
156.
See, the English version is in 158. So
Yes.
why don't you make use of that? After all, they've taken the trouble
Yeah,
to
Mr.
translate. Oh.
Mr. C, I'll read from 158, page number 158. I'll read from the second para. Mr. Silal Fakoma would falsely ask and take money from these contractors even every time they receive their bill. The contractors, however, cannot pay him the entire amount that he had asked for, and so he would enter outstanding amount as a debt that he would ask for later on. A. He had asked for a subcontractor's work on the contract work of Mr. A. Flal Ruenga, Rabung Aiduzol. Retaining wall construction work, it would not be ideal to say no to a person who prepared the bill, and so he was given the work on the same work sites. It's not clear here. Perform, he would normally prepare a bill of 7 lakhs for other contractors, whereas after all deduction, prepare a bill of 21 lakhs for himself. The money was credited into the accounts of Mr. Varmintang Akozol in his SBI account number such and such, and a check was prepared by Mr. Roenga dated 15/11/2019. The check amounting 21 lakhs and a copy of the pay slip is attached. After Mr. Varmintang withdrew money from his bank account, we have heard from Mr. Lal Roenga that the money was handed over to Silal Fakoma JE. It was initially deposited into the account of Van Mingtang according to the desire of Lal Fakoma from the construction bill of Mr. Lal Roenga Rabung Aiduzol wrote. As falsely insisted by Lal Fakoma, Mr. Lal Roenga wrote out check number 1100141 dated 4/1/2021 amounting 17 lakhs, which was credited into the SBI account of Mr. Silal Fakoma. This can be clearly seen from Mr. Lal Roenga bank statement dated 6/1/2020 duly attached. So
This is a statement made by not
before
the accused.
Lordship, before filing complaint to Lokayukta on 20th May 2019, there was
This is by
internal.
the deputy secretary.
Yes, there was internal investigation in the department itself. Because they attached these documents, this letter. So, but because there are another roads also, many roads, but they did not prove. But in respect of A point, they proved it. Investigation was taken place, and preliminary investigation was taken up, and they found only in respect of this road. Because another's also, there's allegation, but they did not prove it in this respect, in this another roads. But in A only, this they filed charge sheet against the appellant. So my point is that even on before 20th May 2019, this imputation, this allegation of accepting 17 lakhs and 3 lakhs was already there. But even they did not make statement anything of such. Only when he was called, they were called at the times of examination and trial on I think this one only 14 June 2023, after a gap of 3 years. That's why their statement cannot be relied upon, cannot be trusted. And one point is that I have also mentioned it is on the record in the court documents. Even in their anticipatory bail petition also, they did not mention that those monies were borrowed money. So
Yes,
relying
what's your
upon
point?
yes, relying upon my judgment, because there are other evidence witnesses also to prove that he accepted, and he himself admitted that also, because even in his statement that regarding giving on that 17 lakhs on 4 January 2020 and giving on that 11 lakhs to the account of the appellant on 15/11/2019, it's all admitted fact.
That's not denied.
That's not denied. And also, even Lal Limpuya, this is witness number 9.
What does
His
he
manager SBI, yes, he was called
let's
upon.
see
It is 50.
say? 50. What does he say?
May I read?
Yes.
I joined the post of branch manager SBI Khosol branch in the year 2020. I am presently serving as a regional manager SBI Bongkon branch. I was serving as branch manager SBI Khosol branch. The SCB personnel came to my office on 5th 2022. I was requested to print out copy of the statement of account maintained between 14/11/2019 to 1/2/2020 on by Van Ming Thanga bearing account number such and such in our branch. Upon requisition made by SCB, I printed out account statement of the aforesaid Van Ming Thanga. While the SCB personnel were in my office, I handed over the same to them. SCB then seized the statement of account maintained by and owned by Van Ming Thanga bearing account number such and such from me. I beg your pardon. I put my signature on the body of seizure memo prepared by the SCB after affirming that the statement of account printed by me at my office on 4th 5th belonging to Van Ming Thanga, and it is the same statement of account exhibit MO9. It was exhibited, which is produced in the court today before me. I was given copy of seizure memo on the same day itself in respect of the statement of account maintained between 14/11/2019 to 1/2/2020 and owned by Van Ming Thanga bearing account number such and such in our branch. Exhibit P12 is seizure memo. Exhibit P12 is signatures on the body of seizure memo. Exhibit MO9 is Van Ming Thanga account number such and such. May I read the cross-examination part also?
But it's not denied, isn't it? So you leave it as this.
Yes, it is not denied. I don't have to read all, because this is all documentary evidence, and which is also admitted that even they did not deny in this pleading also, they did not deny at any point of time. And also they themselves admitted those transactions of 3 lakhs and 17
money
lakhs.
transaction is being,
Yes.
it's clear now, huh?
Yes.
Anything else?
And I skipped my first point, and I already make submission in respect of this point.
The
That
first point,
I,
leave it.
I really want
I
your
will
lordship,
mention.
yes, this my submission to be highlighted in the order judgment
yes, I will
also,
mention
because
that.
this appeal is not maintainable in as much as the one who took part everything, the investigation, the trial who conducted are not arrayed as the party, though there is an order, but that IA is regarding impleadment.
But the last paragraph of the
Yes,
IE.
I can participate,
So
but
you've
Your Lordship
participated.
actually Your Lordship is gracious enough to make submission, but as reading very carefully, it seems that I was not allowed to make submission also. I just have to assist PP on only. On that,
Anyways.
my first point and second point. And that their main point is that no prosecution witness, no prosecution sanction at the
Required,
times
yes,
of
yes.
at the
That
times
local
of giving
Ayuktha-
prosecution sanction, a portion of being heard was not given under section 19, that 1C, that proviso number 2. My lord,
So let's look at the Lokayukta Act. where
Yes, Lordship.
prosecution
Section 22.
sanction is not required. The Mizoram Lokayukta Act, yes. Is it the Mizoram Lokayukta
Yes.
Act?
Yes.
When was it amended?
2015. 2014, the Act
Yeah, 2014 is the act. Amendment on 2000?
17, I think, but I'm not relying upon amended one.
Oh,
I'm
okay.
relying upon original Act, 22.
I think, anyway.
17 in my
Section 22.
22. Sanction not necessary. I admit that there is prosecution sanction in the file, but my submission is that for abundance precaution, because it happened, and the one I submitted in Van Lalmoy case, it's in your hand also. We had done that prosecution sanction also, because there is still confusion now regarding prosecution sanction at all. But in as much as there is a law which is not yet set aside or cancelled by any court of law, it still stands, this section 22. No sanction or approval of any authority shall be required by Lokayukta for conducting investigation by any agency in respect of the cases investigated by such agency on the directions of Lokayukta under 197 of CRPC or Section 19. See, Section 19 of PC Act, as the case may be, for the purpose of making preliminary inquiry by inquiry win or investigation by any agency into any complaint against any public servants, or for filing any charge sheet, or for closure report on completion of investigation in respect thereof before the special court under this Act. Number 2, a special court may, withstanding anything contained in Section 197 of the CRPC or Section 19 of PC Act, on filing of charge sheet, on completion of investigation by Lokayukta or any officer authorized by it in this behalf, take cognizance of offense committed by any public servant. Number 3, notwithstanding contained in subsection 1, 2 shall apply in respect of the person holding the office in persons of the provisions of the Constitution, in respect of which procedures for removal of such person has been specified therein. Number 4, provisions contained in subsection 1, 2, 3 shall be without prejudice to generality of the provision contained in Article 311 and subsection C of clause number 3 of Article 320 of the Constitution. What the intention of this statute is that investigation be expedited, not like before the PC Act or before that Section 17A, even 19 came into play. Lots of complications came up. They came to High Court, Supreme Court, like in Yadiyurappa case, So in my case, this is exactly investigated by any agency on the directions of Lokayukta under Section 19 of the PC Act. It is very clear. They have not challenged here. The appellant have not challenged here, so they could not raise this. That Section 19 clause 2.
I've got your point.
So again, that in that sentence order, there's a very small sentence that no proof of corrupted money and picked by the convicted person.
That one sentence.
But that one, there was no observation, there's no foundation, but that relates to the point 1 in respect of 17, because
in respect of 17 lakhs. 17
yeah,
lakhs.
we cannot deny that, because it is already attained its finality. So, and then, but in respect of point 3, because whether it was, the amount is not important. So even 10 rupees also, it is corrupted money. But the way how that thing, the money was demanded by the public servant, it was quite unfair, being the supervisors of the work, and also moreover, lending and giving money to the workers.
Yes, go ahead. We're almost concluding, so let them come. Yes.
So, those are my submission, Your Lordship. So, and my last point to conclude this, Your Lordship, this is the first challenge I can say that like conducted by ever since Mizoram Lokayukta proper functioning properly. So at the times of giving judgment, and that the trial court, special court also did not nomenclature himself as the special court of Mizoram Lokayukta. It was notified by, during your tenure, I think it was notified. Special court itself is not PC Act, it is special, this Mizoram Lokayukta Act. So again, I want to conclude my submission saying that this has to be handled even in High Court by the Mizoram Lokayukta. So without including Mizoram Lokayukta, so they try to.
So you're still unhappy with
Yeah.
the disposal of
Because,
the IA?
my lord,
You're
my
still
lord,
unhappy with the way the
no, my
IA
lord,
was disposed?
one thing is that this
but
is, impleadment is another
just
thing.
left it, huh?
Impleadment is another thing. Hearing is also another thing. But be there in the party is very important in respect of
Because
preferring
it
an
was so
appeal.
important, you had prayed that you be impleaded. But
Yes.
this court did not allow your prayer and had mentioned that you can participate. So
Yes.
you've participated.
But-
So your this thing will be
Now,
mentioned.
in case if we prefer an appeal, so we cannot directly prefer an appeal. There is embargo. If we are not a party, we are restrained or we are not allowed to make some submission also. This is the things. That's why that's my last
Okay.
submission.
Yes,
Yes,
I got your
really
point.
urge you to highlight in my points. In my point number 1, that's point. Much
We'll
obliged.
mention. Yes, any rebuttal?
I'll make it very short, my lord. At the outset, I think my lord friend is, I hope he doesn't take it personally that I'm objecting to non-arraying Lokayukta as a party respondent. But the only reason why I did not do that is because perusal of the cause title to the judgment and order clearly states state of Mizoram only. As such, arraying the Lokayukta at the appellate
When
stage,
they were not mentioned in the judgment and order.
they were
is
not
it?
mentioned at all. So that
Even
was the only reason why.
Jerry is also not mentioned. They impleaded as the respondent number 2.
Who?
That Jerry Lalrin Sang, it is
Because there's a
in the
direction of
judgment.
He's an informant.
he's a
No, not
complainant.
informant.
Complainant. He's a complainant.
That's why he has to be
The
arraigned as a
complainant is
party.
Aid Zatanga, that from the department.
Okay.
I don't know.
Anyways,
Anyways, that's not important.
Huh.
That's not the issue right now. So anyways, I hope my learned friend doesn't take it personally. That is only the reason why. In fact, as far as I'm concerned, the more the merrier. Now, just to quickly rebut what my learned friend has stated. Now, my learned friend has read out the statement of one Mr. Rosiam Ramdun, Deputy Secretary, PWD, Government of Mizoram, at page 158. Now, the submission of my learned friend was that this statement was recorded as part of their internal departmental investigation. That was his statement. Now, if his statement was so crucial, why is this particular person not called as a prosecution witness? Why was that not done by the prosecution? Do they have something to hide? You are saying that you conducted your internal investigation and you have annexed the statements of these persons, but no, I am not calling you for the trial. Why? Maybe they have something to hide. Maybe they are going to say something that they do not like.
Anyways, he was not made a prosecution witness. Leave it
As
at
far
that.
as that person is concerned,
Yes.
his statement cannot be relied upon. Now, my learned friend has relied upon the judgment of the Apex Court of 2023 for SCC 731.
Yes.
With your Lordship's permission, just 2 paragraphs I would like to revisit that particular case. Basically, it was regarding hostile witnesses and regarding proof of demand and acceptance, so on and so forth. Now, I just want to highlight whether this particular judgment can be applicable, will be applicable in the instant case. I would like to read out para 87 again, Your Lordship.
Para?
87 of that same judgment, that which my learned friend has relied upon.
Yes.
2023, Volume 4, SSC 731. Just a short.
Yes.
Your Lordship has it. I'll just quickly read. Therefore, this court cautioned that even if a witness is treated as hostile and is cross-examined, his evidence cannot be written off altogether, but must be considered with due care and circumspection. And that part of the testimony which is creditworthy must be considered and acted upon. It is for the judge as a matter of prudence to consider the extent of evidence which is creditworthy for the purpose of proof of the case. In other words, the fact that a witness has been declared hostile does not result in an automatic rejection of his evidence. In fact, this favors the appellant. Even the evidence of a hostile witness, if it finds corroboration from the facts of the case, may be taken into account while judging the guilt of the accused. Thus, there is no legal bar to raise a conviction upon hostile witness testimony if corroborated by other reliable evidence. Where is the other reliable evidence? My learned friend has failed to point that out. In any event, as far as this particular hostile witness, that is PW number 4, is concerned, even during his 161 statement, it was always from the beginning maintained that 8 lakhs was borrowed. And he, in his cross-examination by this very counsel, he stated that I had informed the police officer that I had also taken an additional amount of 3 lakhs.
0.8, isn't it? Serial
Correct.
number 8. Huh?
Correct. So throughout, the story of the PW number 4 has been very consistent. It is not the fault of the PW number 4 that the police officer failed to record regarding their 3 lakh. In fact, perusal of the evidence that was already read out, which go on to show that in most cases, the case IO, that is Mr. Jerry, the SI, so inspector, used to record their statement handwritten. Thereafter, it was printed out. So
Where's that? Where's that?
it's I've read it earlier, but I'll come to that again.
Who mentions that? Which witness?
The case IO also.
The case IO himself said that?
Yes, I'll come to that. I'll come back to that later on.
Okay,
But in the
yes.
meantime, I'll just to
Yes.
stay with this particular judgment so that we can move on from here.
Yes.
And the second point that my learned, so as far as this para 87 is concerned, statement evidence of hostile
Cannot
witness
be written off.
cannot be rejected off.
Yes.
Number 2 is that my learned friend has read about that 88.1, so on and so forth, regarding proof of demand and acceptance. Demand by the by the public servant and
Circumstantial evidence is enough.
bribe
That's,
giver,
I think, the point.
yes.
Huh?
So whether this is applicable in the present case or not, because out here the bribe giver gives the money, whether the public servant knowingly takes it, knowingly takes it as an illegal gratification or not, that would suffice as acceptance. That was his case. However, in this instant case, it's the other way around. It is the other way around. It is the PW number 4 who took money from the appellant.
Okay.
It is the PW number 4 who took money from the appellant for construction of his work. And after receiving the bill, he merely returned the money which he had borrowed. So the principle of demand and acceptance, which is mentioned in this particular judgment, would not be applicable. Lastly, so far as this judgment is concerned, at para 90, I'll just read out. Accordingly, the question referred for consideration of this constitution bench is answered as under. In the absence of evidence of the complainant, it is permissible to draw an inferential deduction of culpability, guilt of public servant under so and so. In the absence of evidence of the complainant, in this case, the complainant's evidence is very much available. He has given his statement as prosecution witness number 1. He was the first person who filed the complaint before the Lokayukta. The complainant before the ACB, that is the officer who filed the FIR, SI Jerry Laurin Sanga, his evidence is very much available as prosecution witness number 2.
So PW1, isn't it? Or PW2?
Both of them.
Complainant 1 and 2.
1 and 2. 1 is the complainant before Lokayukta. 2 is the complainant in his before the ACB. He was the person who filed the FIR. So his statements were taken. He was cross-examined. His evidence are very much available. Their evidence are very much available. So as far as this particular judgment of the apex court is concerned, in my humble opinion, it has no applicability so far as this case is concerned. Now,
Except for para 87, is it?
yes, regarding that hostile witness. Now
Bits
again,
and pieces of the judgment. Anyways, go ahead.
and also regarding my learned friend's statement that throughout the entirety of the investigation, they had never mentioned that it was a
Borrowed money.
But if we come to page 28, this is the statement of the Inspector Jarilal Insanga, page 28 of the paper book. Relevant page being page 39, para 9.
Page
31
31.
is the relevant page. 9, para 9. It is a fact that I have not verified whether the reported received money of the accuser was borrowed from the contractor or taking gratification from the said contractor. He never asked. And next at para 32, page 32, para 17 and 19. It is a fact that I have not proved whether the subcontractor Van Mingtonga borrowed money amounting to either rupees 8 or rupees 11 lakhs from the accused. I don't know what kind of preliminary investigation was done, but this is his own statement. So, as far as the monetary transaction is concerned, that is not denied, so I will not elaborate on that. So, in light of those submissions, my lord, again, what I would like to submit is that the prosecution has miserably failed to prove their case so far as this 3 lakhs is concerned. There is no misappropriation of money. Admittedly, during the cross-examination, the PW number 4 has already stated that the amount of rupees 3 lakhs was a borrowed money and that he was just returning the same. And as a result, Your Lordship, my humble prayer is that this particular judgment and order and the sentence order is liable to be set aside and quashed, and the present appellant should be exonerated from all charges with merit, Your Lordship. With that, I conclude my submission.
Lordship, one line only. Can I make a rebuttal? One line.
One
Because-
line, just
Yeah,
one line.
One line.
Ha,
I'll just.
ha.
He mentioned that case IO at
In the cross- in the
yeah,
cross,
yeah, he
ha.
never asked because he never asked. He did not prove that it was a borrowed money because he never asked that he borrowed 17 lakhs or 3 lakhs from the appellant. If he mentioned, definitely he would ask.
Okay,
Had
fine.
he mentioned, had he make such kind of
No
statement,
mention was made.
definitely
I got your point.
he would
I got your
require.
point,
He would
yes.
require. Where is the letters? Where is the bond? That's why he
I
did
got
not
your
ask because
point.
he kept quiet. He kept quiet since 2020 May 2020 May 2020. 3 years. Then after 3 years only this came out.
Okay, fine. Heard Mr. Lal Fakoma, learned counsel for the appellant, along with Mrs. Linda L. Fombal, learned PPE for the state respondents, assisted by Mr. J.C. Lalunsanga, learned special PP for the Lokayukta. Having heard the submissions made by the learned counsels for both the parties, hearing is concluded. Matter is reserved for judgment.
Please be obliged.